It's okay. Sorry. Okay for me to do this. You don't know what. No, yeah, because that's your position.
Good afternoon. Hopefully I've got Jill and Dr. Higgins with me. Thank you for joining the committee. We've got you for 10 minutes this afternoon, so I'll hand over to you to present your submission.
Tēnā koutou e hiuhiu mai nei I tēnei rā, and I hope that you can hear us both.
Yes, we can.
Ko Jill Hoki tōku ingoa. I'm the Executive Director at the Christchurch Methodist Mission.
Ko Jane Higgins tōku ingoa. I'm the Strategic Advisor at the mission.
So the Christchurch Methodist Mission is a social service organisation of Te Hāhi Wetiriana or Aotearoa, the Methodist Church of New Zealand, and we operate in Canterbury, Nelson, Marlborough and the West Coast. So why do we have an interest in this bill? Well, the early Wesleyan Church actively supported and promoted Te Tiriti o Waitangi. In 1840, the Methodist Mission at Mangungu in the Hokianga Harbour hosted one of the largest signings of Te Tiriti. And so the Methodist Church, therefore, has a particular responsibility to honour the faith that those signatories placed in its missionary forebears, and today continues to honour Te Tiriti o Waitangi as the founding document of our nation. Over 40 years ago, the Church committed itself to working biculturally, and since that time, all major decisions within the Church are made when there is agreement between Te Taha Māori and Tauiwi. So Te Tiriti o Waitangi is an agreement between Māori and the Crown, and to propose this bill without any meaningful engagement with Māori is unacceptable.
For our time with you today, we would like to speak to or from our experience as a social service agency, because we think this has something to offer the discussion. And so we draw your attention to our points 5 and 6 in our written submission. These address the impact of breaches of Te Tiriti. In our work, we see daily the impact of breaches of Te Tiriti. For example, among those that our Housing First team works with, and these are people who have been long-term homeless, half are Māori, where only 13% of the Christchurch or Ōtautahi population is Māori. Among our social service clients and in our preschool, again, there is significant overrepresentation of Māori. In fact, our only service where Māori are underrepresented is in our aged care facility. And a significant reason for that is that Māori have a lower life expectancy than Pākehā. Similar systemic inequities can be found across the country, overrepresentation of Māori in poverty, housing insecurity, and poor health outcomes. We know that these inequities are closely associated with breaches of Te Tiriti, with land alienation and cultural assimilation. For example, here in Canterbury, the Crown's failure to honour Kemp's purchase deprived 5 generations of Ngāi Tahu of their livelihood by taking their economic base from them. The history is very clear on this. The impact is ongoing, and we see it daily.
We have the tools to address this impact through the already existing principles that the Waitangi Tribunal and the courts have developed, in particular principles of te tino rangatiratanga, equity, partnership, redress, good faith, active protection, and so on. We're gravely concerned that the bill replaces these principles, in fact, actively excludes them from consideration where such treaty principles would be relevant. And yet these are the mechanisms by which breaches of Te Tiriti and the impact of these breaches can be addressed. In contrast with the established principles, the principles proposed in this bill cannot address the inequities that we see on a day-to-day basis in our work. And so we'll stop there and we look forward to your questions.
Thank you both. Thank you for your submission. Members, I'll open it up to questions, and the first one is from Stephen Abel.
Kia ora, yeah, thank you very much for your very powerful submission. Going back to that original conversation that happened between Māori and the missionaries, is it your view that it was beyond comprehensible that Māori would be intentionally ceding sovereignty?
I'm certainly not a church historian but certainly I don't think that there was any understanding that Māori were ceding sovereignty at that time.
My follow-up is, in terms of what you talked about, the impact of land alienation and cultural assimilation on outcomes for Māori. Do you think, in a sense, this bill is in that tradition of assimilationist acts of Parliament, insofar as it has the effect of nullifying the Māori right to self-determination?
Yes, I think that puts it very well. I think at the heart of this discussion is, if you like, a discussion about cultural identity. And cultural identity is not a simple thing, but this bill glazes over any sense that we have different cultures, and in particular that there is an Indigenous culture in this country. And so in our work, we work really hard to be culturally responsive to people who come to us. And we know that by being culturally responsive, by recognising in particular, for example, tikanga, that our clients respond very well to that, and that their own well-being is deeply tied up with that tikanga and their cultural identity. So to try to say that everyone is the same in a way that I think this bill is doing great harm to people who are not of the dominant culture, which is essentially Pākehā.
Kia ora, thank you.
Thank you. We'll go to a question from Tangata first, and then Duncan, if you had one as well.
Tēnā korua, mea korua mahi. So thank you for your work that you do down there in Ngaitahu land. I'm a descendant of Ngaitahu, and I appreciate you referencing Kemp's purchase and the ongoing economic impact that eventually led to all of the social and health and every other depravity that Māori endure. So my question too is, there's a lot of resource going down the drain right here. So what are some ideas that you might be able to give the government for maybe it's a better place to direct that resource to get some better outcomes, given that Māori in the South Island have had to suffer 5 generations with no economic base? What are some other ways that the government might deploy its resources to help raise the health of Māori across the board?
Oh, that's a very, very large question, but certainly that conversation needs to be held in consultation and together with Māori. But certainly the things that we're seeing is the need for housing. That's a major issue for us. We know it's a major issue through the country. We talked about, we've got 90 people on our waiting list at the moment for Housing First. So it's people who've been homeless for over a year. They need housing. We really need to be building more housing that's actually suitable for people. So that's only one area. Right across the board in terms of mental health, good, strong early childhood education. There are certainly places that we could be putting our resources rather than an expensive select committee process.
Yeah,
I think also just to acknowledge that people are experts in their own well-being, and their cultural identity is an absolutely fundamental part of their well-being. And so to recognise that cultural identity and to recognise that people become healthy within an environment that recognises and honours their mana, I think is very important.
Kia ora, tēnā korua.
Sure, thank you, Tangata. Is there any further questions?
Yeah, I will ask mine if I may, James. It was touched on. Look, there's a lot of narrative around this about having different rights based on ethnicity and better rights for Māori. And some of the stuff you've said today has actually touched on that. But I want to give you an opportunity to talk about the actual work you do and how taking a treaty principles approach gives better outcomes for all of the people that you help here in Christchurch Utahi.
Well, certainly if I look at our Housing First service, we really work hard to operate on a bicultural model there and actually recognise that 50% of the people we work with are Māori. And so that impacts on the staff who we employ through things like karakia waiata being very much a part of the work that we do, and for a lot of Māori actually helping to re-engage with whānau, hapu and iwi who they may have become disconnected with over time.
Thank you both. Thank you, Duncan. Look, appreciate your time with us this afternoon and for providing your submission. Thank you.
Kia ora. Kia ora.
We're going to move on to a submission now from Citizens Advice Bureau New Zealand, and with us in the room is Kerry Dalton. Kerry, thank you for joining us. We've got you for 10 minutes this afternoon, so if you'd like to begin your presentation.
Tēnā koutou katoa. Thank you very much for allowing us to be heard on our submission. It's something that we feel very strongly about. I'm just going to go through a brief overview of the submission and then open up for questions. So the CAB provides free, confidential and independent information and advice to anyone. The CAB helps people know what their rights are and how to access the services they need. And we use the insights from clients' experiences to show where policies and laws and their implementation are having a negative impact on people. The CAB works for positive social change and a just society, and we're a universal service for everyone. And as an organisation that supports people to know about and understand and access their rights, we acknowledge Te Tiriti as the founding document of our nation and the rights it conferred on Māori as tangata whenua, the Indigenous people of our land, and to tangata tiriti. Our opposition to the bill, and we strongly oppose it, is based on our commitment to an honourable treaty relationship. As set out in our submission, the CAB and Aotearoa has always recognised Te Tiriti o Waitangi as the founding document of our nation, and this is reflected in fundamental documents of our organisation. We recognise Te Tiriti within the constitution of our national organisation and in that of every CAB in Aotearoa. There is acknowledgement and commitment to Te Tiriti as part of the volunteer agreement that every CAB volunteer must sign to be accepted as a volunteer. It's part of our membership principles, and we have a kaupapa, Mauri Manaia, which seeks to honour our tohu, our manaia, and give life to that through promoting te reo and tikanga within the organisation. The key point I want to make from our submission is that we consider it to be unjust and wrong that the bill was developed without the agreement of Māori as signatories and partner to Te Tiriti. We are deeply concerned that the current government, acting as the Crown, one treaty partner, has developed and proceeded with this legislation without the agreement and involvement of the other treaty partner. Given the history of breaches of Te Tiriti by the Crown, we consider that extreme care should be taken to engage meaningfully and in good faith with Māori as treaty partner in regard to anything that has the potential to limit and change their Indigenous rights under the established meaning of Te Tiriti. And hearing from submitters today, it was distressing to hear that some of those hapu and iwi who have gone through the settlement process and received apologies from the Crown for accepted breaches are now questioning the integrity of the apologies made by the Crown. The fact that consultation involvement with Māori as a treaty partner is deeply disappointing, and it means that the Crown is acting as if Te Tiriti doesn't exist and there isn't a treaty partner. We note that the Waitangi Tribunal says of the bill that it would reduce the constitutional status of the treaty of Te Tiriti, remove its effect in law as currently recognised in treaty clauses, limit Māori rights and Crown obligations, hinder Māori access to justice, impact treaty settlements, and undermine social cohesion. A select committee process and a referendum as the means for Māori as a treaty partner to engage with the bill does not recognise and respect their status as a treaty partner. We consider that the government acting as our representative as the Crown has not acted in good faith in relation to Māori as the treaty partners of the Crown, and therefore the bill should definitely not proceed. We had hoped that it would not proceed to this stage. As the CAB, we have a vision and work for a decent, fair and just society, and an honourable treaty relationship is fundamental to this. That is the key thing that I would like to emphasise in the submission today. And also to say that as a universal service that has that acknowledgement and commitment to tiriti, it doesn't take away from our service being available and accessible to everyone. We're a universal service. Kia ora. I'd like to open up to questions.
Kia ora, Kerry. Thank you. We've got time for questions. The first one's from Steve Abel.
Kia ora, thank you very much for your very strong submission. I wonder if you can please expand on the point you make in your near final paragraph, that in your Citizens Advice Bureau analysis, Māori face significant barriers to access to justice in relation to knowing and acting on their rights. And these issues exist in the context where an experience of inequity for Māori today is grounded in the ongoing impacts of colonisation, structural racism, and the Crown failing to uphold the rights promised to Māori under Te Tiriti. How do you then respond to the author of this legislation, which says it's correcting a privilege to one group at the expense of another, and that group is that currently has privilege in the view of the author is tangata whenua Māori?
I say that that's misguided, and it's also ignoring the evidence that Māori are adversely affected in most of the areas of social experience. We see Māori overrepresented, for instance, and we did an analysis of our client inquiries from Māori, overrepresented in people coming to us because they couldn't put food on the table and needed to access food banks, emergency accommodation, and also in digital exclusion, which is fundamental often, people being able to access government services is fundamental often to them being able to access their rights. And a number of Māori are they are overrepresented in those people who, for various reasons, cannot operate online or find it difficult.
So would you say that assertion of that privilege is really a highly outrageous one, and that in fact for us to achieve equality in this country, it needs to be done through better enabling that expression of Māori self-determination?
I would say that there needs to be an acknowledgement that there has been harm to Māori from breaches of Te Tiriti to date. And while there is a process of redress, that there is also ongoing harm from those breaches of the treaty, which in many cases removed an economic base from iwi and hapu, and that therefore there has to be particular and special consideration given how to ensure equity for te iwi Māori.
Kia ora.
Thanks, Kerry. We'll go final question from Takata Ferris.
Tēnā koe, Kerry, ngā mihi. Hey, given you've got a real broad catchment of people across the country, does your organisation have a feel for how the public are feeling, or what the bill is sort of impacting them just on a broad sweep?
What I would say is that we are concerned about this feeding into false ideas and false narratives. The one being that Steve Abel just asked about the fact that the acknowledgement of Māori Indigenous rights somehow takes away from other people's rights when it's an and. And as I say in the submission, it is the basis, acknowledging Māori rights under the treaty as tangata whenua is the basis for a decent and just society.
Thank you, Kerry. Thanks, folks. That's the end of time for this afternoon. So just want to extend our appreciation for you being with us to provide your submission. Kerry.
Kia ora.
We're now going to invite Kendall Clements, if Kendall's here. No. Oh, Kendall, you're online. Thank you. Kia ora. Thank you. Welcome to the committee. We have you for 10 minutes to provide us with your submission, so I'll hand over to you.
Tēnā koutou katoa. I'd like to thank you for the opportunity to have this kōrero with you. I felt I'd said most of what I wanted to say in my written submission, and I'll just summarise a couple of what I think are the main points from that, and then I'd like to invite questions, because I see the only way out of this situation is through good faith dialogue. I think we need to focus more on process, and I think a lot of that to date has been negatively impacted by sort of assumptions of bad faith. And I think there's also a lot of ideology embedded in this. I follow US politics fairly closely, and you can see a lot of great similarities despite the massive differences in the issues that we face here. And one of the really unfortunate things that I think has happened is the way that opponents of the bill have resorted to ad hominem and intimidation. I mean, calling people racists because they disagree with these fundamental aspects of New Zealand democracy is just completely counterproductive, and is actually one of the main reasons why I think we do need some form of process. But we need to align the many problems that face all New Zealanders, including Māori, with real solutions. And we can't just rely on slogans, name calling, and just sort of make this a naked contest for power. I've said in my submission that I don't think a referendum is the way to go, some form of plebiscite. I mean, the US just elected Donald Trump, and I doubt that many of us on this webinar actually agree that that's a good outcome for certainly the rest of us who aren't many of us who aren't in the States. I'd just like to read a couple of quotes from David Longy's Bruce Jesson lecture, which have influenced my thinking, and this isn't the only document I've looked at. But David Longy, obviously not a paragon of the far right. So I'm just going to read two short quotes. First one is, democratic government can accommodate Māori political aspiration in many ways. It can allocate resources in ways which reflect the particular interests of Māori people. It can delegate authority and allow the exercise of degrees of Māori autonomy. What it cannot do is acknowledge the existence of a separate sovereignty. As soon as it does that, it isn't a democracy. We can have a democratic form of government, or we can have Indigenous sovereignty. They can't coexist, and we can't have them both. And the second one is, here I come to the dangers posed by the increasing entrenchment of the treaty and statute. The treaty itself contains no principles which can usefully guide government or courts. It is a bald agreement anchored in its time and place, and the public interest in it is the same as the public interest in enforcing any properly made agreement. To go further than that is to acknowledge the existence of undemocratic forms of rights, entitlements, or sovereignty. Now, that doesn't mean we don't need to have a dialogue. That doesn't mean that the treaty articles should not be honoured. That doesn't mean that that wrongs shouldn't be made right. But it does mean that we need to proceed very carefully, because the way this has been handled in New Zealand so far has really generated a lot of negative publicity about our country, and that's bad for everyone. And I'll shut up.
Thank you, Kendall. The time is yours to use as you see fit. You don't need to shut up, but we appreciate you providing your submission. We've got questions. The first one is going to be from Todd Stevenson, then we'll go Steve Abel and Tracy McClellan.
Thank you, and thank you for your submission. Just turning to the bill itself, in clause 6 obviously outlines the draft principles that are contained in the bill. Do you have any comment on those principles as they stand?
I think that I don't want to go into the details of what's actually in the bill per se. I'm more concerned because I don't think this bill is going to proceed. But what I want to use this opportunity for is to encourage people to engage in good faith. We need to sort of move back from the brink on this. So we need a better way of approaching the problems, because I don't think we can continue down the path that we've been on with the way that the principles have just been not legislated, but developed through a judicial process.
Thank you, Kendall. We'll go to Steve and then Tracy.
Kia ora. Thank you, Kendall. I actually attended that David Longy speech in 2000. It was very disappointing at the time, I can say. The thing I wanted to say was you recognise that in the process of colonisation, that the atrocities committed, the loss of land, the attempts at assimilation and denial of Māori rights and denial of sovereignty are all part of a long history and tradition of colonisation, which is founded in a principle of white supremacy, really. So those kind of tropes of colonisation are inherently racist. And so when we encounter modern day expressions of those tropes, the desire to assimilate, to deny Māori their self-determination or their sovereignty, is it not reasonable and correct that we should point out what underpins a desire to do that to an Indigenous group of people, that it is founded in ideas of white supremacy or racism?
No, I don't. I don't agree with that. I mean, are you suggesting that David Longy was a racist?
No, I'm not, but I'm suggesting that there's a difference between the individual being a racist, and it's not very useful to focus on that, and understanding that the structural concepts that underpin certain things that are being done are coming from a place of racism as a kind of a framework for seeing the world.
I don't see how that is a helpful framework for solving the problems we have in New Zealand at the moment. If you just want to focus on grievance, I appreciate that wrongs were done to Māori. I fully acknowledge that.
I'm trying to clarify whether you acknowledge that those wrongs were done from a place of racism. Do you acknowledge that there was racism in the colonial actions, if not today, in the past?
I think all sorts of things were going on, some of which were racism, some of which are probably just stupidity or greed. But I don't know how that helps us now. Okay, and forcing everything through this lens, I think, is counterproductive.
Thank you, Kendall. Let's move to the next question. We've got a question from Tracy, and then we can finish with Tangata.
Thank you, and thank you, Kendall. You may have already answered this in your response to Todd Stevenson's question, but you did mention a couple of times during your submission about the need to find solutions to real problems that we're facing. So what problem do you think, in your eyes, what problem is this bill attempting to address? And if you can articulate that, how do you think the process, which is another concept that you've highlighted as being important, how do you think that this particular process is done as a means by which to effectively address that problem?
Well, there's a lot in there. I think that this bill was an attempt to address the ongoing issue of open-ended interpretation of Te Tiriti. And as I said, I don't agree with the black and white version of what the law is proposing. I do have sympathies for what the bill was trying to achieve. So my question is, if we don't do something along these lines, what's the solution? I just an endless sort of, at what point would we get to a stage where, as I said in my submission, where all New Zealanders have equal democratic rights and are equal before the law? I'm saying I don't think we're at that point now, but we need a mechanism to get there. I don't think this is the perfect mechanism, but I think it's pointing at some of the problems that some of the other submitters have mentioned, particularly in terms of the way that Geoffrey Palmer framed this originally, which I thought were inherently problematic. But it's not a matter.
Thank you, Kendall. Sorry to interrupt. That's the time we have for the session today. So I just want to acknowledge your submission and for spending the time with us this afternoon. We do appreciate it. Thanks, folks. We're going to invite now Natalie Coates up to the table. Natalie, thank you for your submission. We've got you for 10 minutes this afternoon, so I'll hand over to you.
Tēnā koutou, e te komoti, ko Natalie Coates aho. I am currently co-tumuaki of Te Hungaroia Māori, but my learned colleague will be making a submission on behalf of Te Hungaroia Māori on Thursday. I am here to talk to my personal submission that I made as a descendant of Ngāti Awa, of Mātātua Wakawhānui, of Ngāti Hine, of those rangatira that sign Te Tiriti o Waitangi, and as a lawyer, barrister, who happens to have some knowledge of how Te Tiriti intersects with law. So there are a couple of points in my submission that I wanted to emphasise. I apologise for any repetition. I've been unable to watch all of the submissions this morning, so not sure what's already been covered. So the Waitangi Tribunal has said that if the bill were enacted, it would be the worst, most comprehensive breach of Te Tiriti in modern times. That's not an exaggeration. This bill violently strikes at the heart and soul of Te Tiriti, our foundational constitutional document. It's one party to the treaty, the Crown, reimagining in a completely novel way, reimagining it, Te Tiriti, in a completely novel way that strips out the primary guarantees and the promises to Māori, the other party to Te Tiriti. You cannot get any more bad faith than that. I think one of the worst parts of this bill is that it's akin to a taniwha telling you that it is wearing the korowai of Te Tiriti on its back. It draws on certain elements and words of Te Tiriti, but twists and recasts them in a manner that ultimately bears little resemblance to the original promises and the guarantees that were made to Māori. The use of the structure of Te Tiriti and fragments of its language is a cunning way to masquerade Te Tiriti and attempt to legitimate a redefinition endeavour. However, those proposed principles are but a warped shadow of Te Tiriti itself. The rangatiratanga of rangatira and hapu are gone. The full, exclusive and undisturbed proprietary rights that Māori were guaranteed as long as they wished to retain them are gone. Beyond general citizenship rights, the only remnant Māori rights that survive these principles are those confined to treaty settlements. Treaty settlements were not designed to codify the Crown's treaty obligations going forward. If iwi had known that, they would never have signed up to them. Treaty settlements, where Māori settle for often less than 1% of the value that was taken from them, are an expression of aroha and grace by Māori to Aotearoa, with a view to moving forward from an ugly past into the future with a more treaty-consistent Crown, as usually promised in those treaty settlements. They do not and were never intended to embody the full treaty relationship going forward. This bill flies in the face of them whilst purporting to try and recognise them, and in doing so will create a legal conundrum and confusion. It also breaches the very intent of what underlies treaty settlements. One of the examples of the trickery or sleight of hand being played in this bill is the clause that says the proposed principles do not alter or amend the treaty itself. That provides no comfort. Sure, we do not have anyone going down to the archives and doing a tracked change version to our original document. But whenever Te Tiriti is legally relevant in the law, those incorrect principles that are amputated from Te Tiriti itself will replace Te Tiriti. So whilst it says it's a non-altering clause, it amounts to a full legally sanctioned rewrite of the Treaty of Waitangi. A few final points. This bill would also shake the foundations of legal certainty in our country. It would result in obliterating 40 years of jurisprudence and require relitigation across all areas of law where Te Tiriti is relevant. What is proposed here strays into territory beyond what is constitutionally appropriate behaviour by the executive and by Parliament. It's seeking to turn a fiction into legal fact. The bill does not contain a legitimate interpretation of Te Tiriti, nor reflect what an honourable Crown, particularly one that is a party to Te Tiriti, should be doing. What I would encourage people to think about, given some of the rhetoric surrounding this particular debate, is how our democracy can be read consistently with the recognition of Indigenous rights and our founding constitutional document. This is not about special rights for Māori. It's about the recognition of pre-existing rights and the arrival of a new people in power in town and how we can coexist. Democracy can be about us choosing to be a country that honours our history, our foundations, whilst also acknowledging the importance of equality, like we already do through the Bill of Rights Act. There are many countries that do this. Canada, for one, has treaty rights being upheld in their written constitution. Te Tiriti is a beautiful and inclusive document that has a place for us all, and we deserve a healthy constitutional debate around these matters, not one that casts shadows, creates confusion and embeds misunderstanding and mistrust within the general public and Māori, or that stokes dissent and division. That is what this process has done. I urge the Select Committee to recommend that the bill be abandoned and that the government continue to work with Māori to honour Te Tiriti o Waitangi. Kia ora.
Kia ora, Natalie, thank you. We've got a number of questions. I'll take them in order as Ginny, then Debbie, then Tamitha, and then I'll circle back to Duncan. Sorry, Duncan.
Kia ora, Natalie, thank you for coming along. I appreciate having your expertise here today. One of the things we've heard today is that an argument that judges shouldn't be part of making these decisions, of the courts don't have a role in democracy, that democracy should sit with Parliament and politicians. And there's a common misperception in the general public that that's not part of our democracy. That's quite a big thing to try and explain and have a good debate about publicly. Do you have any insights how we get around that difficulty?
Yeah, I think one of the dangers that we've seen arising over the past year or two has been the undermining of the judiciary. Like, the judiciary is one of the key prongs in the separation of powers, and actually you need a public that trusts the judiciary for power to work in Aotearoa in general. And so undercutting what it's doing, which is legitimately interpreting the case before it and the law before it, which refers to the principles of the Treaty of Waitangi, is a really unhelpful thing for our democracy in general. It undermines our democracy and its very functioning. And actually, a healthy judiciary that does its job separate from Parliament and the executive is key.
Thanks, Natalie. We've got Debbie and then Tamitha.
Thank you, Chair. Atina Natalie, it's great to hear your submission. In your submission, you spoke about this bill a step backwards, locking the treaty into a static, outdated framework, and mentioned iwi settlements in the aroha to the nation and their desire for peace. In your experience, relitigating and the risk that this does, and relitigating not only current settlements, but historical settlements, and having a government that ignores Indigenous rights in Aotearoa, what does that look like? What does that look like, particularly for you in your sphere of industry and influence?
Well, what this bill would do would obliterate 40 years of jurisprudence that's built up around this particular subject matter. And so Te Tiriti o Waitangi, as you know, is pepper-potted across a whole range of different pieces of legislation and is relevant across all areas of law that are relevant to Māori, which is most areas of law. What this do would require relitigation of what this all means. Because on the one hand, it's saying let's uphold treaty settlements, what that recognise an ongoing relationship in accordance with Te Tiriti, whilst also saying here's how you define them. Like, it would just create this extremely uncertain legal landscape that would need to navigate for a long time.
Thanks, Natalie. Next is Tamatha Paul, and then Duncan if we have time.
Kia ora. What do you think about the way that Sir Apirana Ngata's interpretation of the treaty has been used throughout this whole debate over the last year at least?
So, to be careful at that, sorry, the Apirana Ngata was, of course, a great man and a great rangatira and a great statesman in Aotearoa, but that doesn't mean his views on the treaty are correct. And I think what needs to happen is that, or I think what's happened is that his words have been taken out of context and weaponized in a way that I think is terrible, actually, and that doesn't honour him as a person either. So it needs to be seen in context, right? So he was writing and made those comments at a particular time in our history where Te Tiriti o Waitangi had been right roundly dishonoured. It needs to be taken in light of how he saw te ara mō Māori, e haere ana ki mua, tōringa ki ngā, ia te tērā kupu, ko tōringa ki ngā rākau a te Pākehā, ko tō ngākau ki o taonga a o Tipuna. He had a particular vision for Aotearoa, but also it needs to be taken in light of the overwhelming amount of work that has been done since that time by historians, by academics, by an independent commission of inquiry, by lawyers, by interpreters,
Thanks,
etc.
Natalie. Sorry to interrupt, but we're at the end of the time for the session. So just on behalf of the committee, acknowledge you being with us to present and for spending your time with us this afternoon.
Kia ora.
But we're going to now move to a submission. I'd like to invite Ngawi or Taranaki to the table. We've got Jackie King and Emma Gardner to come with us. The team are going to speak in Te Reo Māori, so there is live translation for MPs at the table. There is no live translation for the room. If you'd like to listen to translation, you can go to Committee Room 4 and it'll be streamed. Kia ora kouroa. Thank you for being with us. Nice to see you in person. We've met several times. I'll put 10 minutes on the clock and we'll hand over to you to start your presentation.
Kia ora. Kato he au, kato he au. Kato he au ki Taranaki. Ki taku kāra ka whakaurau te ai te motu. E nei, nei. He whakahi ana mātou te piri he kia nei ko te principles of the Treaty of Waitangi Bill. Ko tēnei te tauaki no ngā iwi o Taranaki, ara no ngā iwi o ngā rauru ki tahi, ngā ruahine, Ngāti Maru Wharanui, Ngāti Mutunga, Ngāti Ruanui, Ngāti Tama ki Taranaki, Te Aotearoa, Taranaki iwi. Kei tēnā iwi, tō rātou aki rangatiratanga, ko te manako a tōna wā, ka tū motu hake, o tātou iwi ki mua I te aroaro o te komiti nei. Kia whakahua I o rātou ake whakaro mō te pirina. He kōrero, whakara popoto, noa tēnei I ngā tini raru o te piri. Ko Jackie King, tōku ingoa, kua riro ngā maua o Emma Gardner, hei whakamoio atu kia koutou ngā āwangawanga o ngā iwi o Taranaki.
Auwe e tangi tonu ana te piukara. E rua ngā wakaro mātua o te tauaki nei. Kātai, kaore he kiko ki te pire nei. Kā rua, he kōrero o ka tūpato tēnei ki te kāwana, ki ngā kāwana katoa wai ake nei. I te tuatai, kaore he kiko ki te pire nei. Ko te tiriti e wakaitanga o ngā rōpu e rua. Ko ngā rangatira o ngā hapu o New Tirene, ko te kārau nā. Tētaia te rā weke I tēnei tiriti, ina potai ana te rōpu kua wakaitia. I mua tonu mai o ngā Iwi Settlements Act, ka aina tia e ngā rōpu e rua a rā ko aua iwi ko te kāwana i te puka tuku. He tika me pēnei hoki te tūkanga kia wakarere ki ai ngā āhuatanga o te tiriti. Kore he kiko ki te pire nei. Kota I mano e 800 ana e ngā kupu o te pire nei. Roa ake ngā tuinga rua I roto I ngā kura tuarua. Ko te aurua o te matu kei ngā explanatory notes. E wakaiti nei te pire I ngā tūkanga o te wharemata. Wai hoki ko mātou ngā iwi o Taranaki. Ko te wakataunga o te traipūnara o Waitangi. Kaore rawa te pire e eke ki te taumata e tikana. Ko te wakataunga o te tau o te ture. Kaore rawa te pire e eke ki te taumata e tikana. E ai ki ngā ture o te ao wānui. Kaore rawa te pire e eke ki te taumata e tika ana. Ko tētai o ngā rūpau e pau tonu ana ki ngā karere o te motu. Ko tēnei mea te ōritetanga. Kaore au mo te waka I te wakaro mātua o te ōritetanga. E rangi, e hara te tiriti I te wā I tika, ei kawe I taua mātapono. Me aro kē atu koutou ki te ture kāwanatanga, arā ko te Constitution me te Bill of Rights. E no o mātā muana ko te rangatiratanga o ngā uri, o ngā wānau, o ngā apu, arā ko ngā iwi o Taranaki. Kāti te rā weke I te tiriti. He kōrero waka tūpato tēnei ki te kāwana. Ki ngā kāwana katoa wai ake nei. He pau noa te pire. Ei waka āraihia ngā tini pire o te kāwana. Ko tātou o Aotearoa e no o pōraru ana. Te maa kē mai nei o ngā pire e tūkino nei a mātou ngā iwi o Taranaki. Mātou ngai Māori, tātou katoa o Aotearoa. E ai ki I pāti, kaore rawa rātou e o kai ki te pire mō ngā pānuitanga kei te aere. Nō reira, kaore he take ki te hamahama haere. Tēnei mātou e hamahama tonu ana. E hamahama tonu ana. Kia mātua mō I te kāwana, me ngā kāwana e wai ake nei, kaua e rā weke I te tiriti. I mua I tā maua wakakapi I te kōrero nei. He tika me wakautu ki te I o ngā kōrero I puta I te ata nei. Ngā kōrero nā tete I tangata ki tua o te taiata e ki. I wakataurite ia I ngā hara o te pakanga tuarua o te ao ki tērā o ngā matapono o te tiriti. Nā wai kāhua. Nā wai kāhua. Kaore rātou ngā morehu e hua ana mai ērā kōrero wakaiti. Nāna a nake kāhua. Hei wakakapi. Hei te wiki nei, ka waka takotongia te pire o Taranaki maunga. Kia waka mana ia e te ware paremata. Au e te mamai. Aha kua tona hoki ngā mai. E murua tonu tia mātou e te kawana na ēnei mai tini anga o te pene. O ngā pire o ngā ture. Ko tēnei pire, ka noo ai kaupapa tāmi I a mātou. E waka ngū nei I a mātou ngā iwi o Taranaki. He mai tūkino tēnei, e takataka I nei I tā mātou rangatiratanga. Me aukati te pire e tēnei kilomiti nei, e te whare paremata. Ka mutu. He piki mai pū, ngare unga, rangi mai te piukara. He tohu riro, ngā mona e, rere te maunawa. He tai e pāti,
ke tike te tae pai nā tupuri. E tae papi ko maroa wana te maunawa. Tūki atu tū I mai o taua neiri ngā ringa. E te roa riki kwini tiriti ke taunawa. Pi ho mai e kawana ko ahau ko ariki. Ko toe taku hono ngā e te tuini kai maunawa.
Kia ora kōrua. We've got a question from Todd, and then if we have time from Debbie.
Thank you for coming and presenting today. Just want to go to page 3 of your submission, and you actually outline the treaty principles that the Labor government did in 1989 against the principles in this bill. Do you think there are some similarities between some of those principles?
Ka, kore rawa he ori te tanga. I te tuatai, ko ngā māta pono e kia nei ko ngā principles of te tiriti, kua wāngaihia e te kārauna I ngā rautau kua paure. E pāna tērā ki te wanaungatanga o te kāwana me te rangatiratanga o ngā iwi. Engari, ko ngā mātapono I rutu I tēnei pire, e hāngai tonu ana ki tēnei pō tanga, he wakaitanga I wainga I ngai Māori me ngai Pākehā, engari e hara tērā I te tika. No reira e ka, kaore he hononga I wainga I ngā mea e rua.
Thanks, Emma. Thanks, Jackie. Look, that's the time for the session today. So just want to acknowledge your submission and for being the last person today. Folks, we're going to go to a submission now online from Elizabeth Rata, who's going to join us shortly.
No. Oh my God.
Got Elizabeth there? Let's just bring the next submitters in about 30 seconds before we do the finish. Oh, thank you. Good afternoon, Elizabeth. Thank you for being with us today. Welcome to the committee. We've got you for 10 minutes this afternoon, so I'd invite you to present your submission.
Oh, good afternoon. Thank you for the opportunity to present. I'll speak for 5 minutes and then I'll take questions. What is the best title given to any New Zealand legislation? My money is on the 1877 Education Act. It's an act to make further provision for the education of the people of New Zealand. So as early as the 1870s, there's a commitment to a united people belonging to and benefiting from the nation New Zealand. Nearly 150 years later, that commitment is under serious threat from those who would replace liberal democracy with tribal sovereignty, and by doing so, will create a racialized society, apartheid. Consider the two words, liberal, democracy, and their connection. Both give us something that none of our ancestors living in tribal kinship groups had. Democracy gives us a system of parliamentary sovereignty, of law, of regulation. It recognizes that our common humanity justifies equal rights. Those rights belong to the individual citizen, not to the group. The word liberal gives us the freedom to be different, either as individuals and in voluntary associations based on shared interests, which could include heritage, culture, language, sport, politics, religion, music, and so on. That is what makes liberal democracy remarkable. As citizens, we have the same political and legal rights. As members of civil society, we are free to be different. This is an enormously important point. It's the combination of rights, responsibilities, and freedom within democracy's governance and laws that makes the modern world vibrant and prosperous. That's why I support the Treaty Principles Bill, because it provides a coherent and succinct statement capturing what liberal democracy is. Something we should all know, especially members of Parliament who represent us, the people of New Zealand. First world nations need liberal democracy's creative tension. It's an invigorating tension between rights, responsibilities, and between having the same rights and having the freedom to be different. The bill is the symbolic link to the hope found in both the 1840 Treaty of Waitangi and in the 1852 Constitution Act. 19th century New Zealanders, especially those who had been slaves, decimated by war, of low genealogical birth status, or from impoverished backgrounds, they put their faith in a peaceful and prosperous future for their descendants. In the 21st century, we can strengthen this faith for our descendants by agreeing to the principles in this bill. New Zealand's future may be that of a prosperous first world liberal democracy or a third world retribalised state.
James.
A first world tribal nation is a contradiction in terms. It is not possible. There can be no prosperity without individual equality and freedom. There can be no social equality without prosperity. We are at a very serious crossroads. The value of the bill is that it not only forces us to confront this fact, but allows us to do so within the parliamentary select committee process, rather than through cultural posturing, intimidation, or perhaps even violence. The very existence of the bill is liberal democracy in action. Thank you.
Thank you, Elizabeth. We've got a few questions lined up. The first one's from Dr. Webb, and then Takata, and then Timothy.
Well, good. Thank you, Mr. Chair. I was fascinated that you used the Education Act of the 1870s as an example of liberal democracy. I'm assuming you've read it and you know that free and compulsory education wasn't available to Māori children until the 1890s, and that act only applied to Pākehā children. In light of that, I'm perplexed with your stance that there shouldn't be any kind of distinction or special duty to Māori, given the fact that the full rights of participating in a democracy were only just given, 100 years ago.
Is there a question in there, Dr. Webb?
Yeah, there was. My question was quite clearly stated. Can you explain, given that Māori weren't given the rights of full citizenship in our liberal democracy, why it is that you seem to say there should be no differentiation in treatment between Māori and Pākehā?
Māori had government-provided education from the 1867 Native Education Act. The 1877 Act included everyone, except there was a provision for those who did not want to be compelled to attend government schools not to go. So you had the tribes of the north, the east coast, south and so on, very keen to establish schools. But that exemption recognised that there were some groups, particularly, of course, Waikato and Taranaki, who were opposed to the government, given what had occurred during the land wars. That exemption enabled them not to have to send their children to school until the exemption was removed in 1903. Now, you will be aware, surely, that the 1877 bill had a number of exemptions. There were exemptions for children based on geographical locations, who couldn't get to school in some cases. There were exemptions for children with disabilities. There were a number of exemptions. And what I think that shows is something we see in the New Zealand character, which is an interesting combination of idealism and pragmatism. So throughout the 1877 Act, you will see a number of exemptions. Secularism, for example, there are other exemptions. And I think that is very much part of the tolerance required in a liberal society. There will always be some people who will simply refuse to do what the law says. And the pragmatic part of being a New Zealander is that our laws often have exemptions.
Thank you, Elizabeth. I think that's well addressed. We'll go to a question now from Tangata Ferris.
Kia ora, Elizabeth. I'm sure you'll recognise and agree with me that Māori had pre-existing rights before anyone else showed up. So my question to you is, where did those rights fit into the liberal democracy idea? And just secondly, can you identify for us all one modern day colonial society where the Indigenous people have thrived under the liberal democratic idea?
Oh, thank you. Yes, quick answer to your two questions. The first one is that in pre-colonial New Zealand, slaves did not have rights, nor did low caste tribal members. Now, in response to your second question, my answer would be New Zealand. Have a look at the burgeoning Māori middle class. Have a look at the numbers. Right from the 1960s, there has been a steady increase in the numbers of Māori moving into the middle class, who are doing very well, which is excellent.
Okay, thank you, folks. That's the time we've got for the session today. I just want to extend the committee's thank you, Elizabeth, for joining us and providing your submission. We're going to move to a submission now from Paul Chrystall. Paul is going to join us online as well. Paul, good afternoon. Thank you for being with us today. We've got you for 10 minutes this afternoon, so I'll just invite you to begin your presentation.
Indeed, and thank you very much for the opportunity. And it's been interesting watching other people present on both for and against, obviously, and it's wonderful to be part of a democratic process where we can discuss the laws that are made that affect our lives. I'm not going to go through the my presentation because I understand that you've all read it, but I just wanted to briefly introduce this time before questions. In reading through some of the other submissions, in particular the Maori Council submission, they asked the question, what is the problem? So I thought I should start just briefly there. And it's really a set of questions. And the question is this: how did we arrive from 1975 Treaty of Waitangi Act with its idealism and its constructive nature and the success it brought, and end up now being a country that where we find that we spend millions of dollars playing whale songs to kari trees to check whether that will in any way cure kari dieback? How did we go from the brilliant settlement that Ngāti Whātua achieved, and then their extraordinary success, their investment success, and then end up being a country where professional bodies such as land agents have to go through obsequious, trite causes on the Te Be Te Treaty partner. How did we go from the settlements of mid-North Island tribes and find that the port of Tauranga was unable to be developed for several years as it was stonewalled by parties who were seeking large emoluments of money? And I guess above all, how did we go from that idealism and the practical constructive nature of the settlement legislation to a place now where we are dealing with the utterly impractical issues and proposals of say he puapua? So the proposition that I put in my submission was simply we got to this position because we made a mistake. Parliament made a mistake. It did not define the principles of the treaty. And the subsequent mistake was the mistake that started with the perhaps inadvertent use of the term partnership in the lands case, but it's nevertheless now been concreted into our modern understanding of the treaty. And partnership, in my view, is the doorway to the questions around sovereignty and the issues of differential voting rights. And so it's sovereignty and partnership that we got wrong. And I'm not going to go through the clause by clause analysis that I put forward in the paper. It's not, in my view, that controversial. It's there are left and right wing people that accept or believe that the courts have simply misunderstood the treaty and partnership is a contradiction of the clause of the treaty. But I do want to just, before I stop, reflect on that fantastic debate between Aotearoa, Taunui, Frederick Manning and Hobson, when they asked Hobson and suggested instead of sovereignty being offered to the Queen, that instead it would only be offered over Pākehā and sovereignty would be retained by Maori over Maori. And Hobson absolutely rejected that proposition and said sovereignty is universal and it must and indivisible. And so these negotiations were had at the time, and if people have the time to, and I believe everyone should read the transcripts later of the Koimaramara conferences where these things were reconfirmed, I think we come to a position where we can no longer leave the evolution and the endless evolution of what it means and what the treaty means inside of our legislation. We need to be able to see it addressed by Parliament. That's all I have to say. I'm just open to questions.
Thank you, Paul. We do have time for questions. The first one is from Tangata.
Kia ora, Paul. Thanks for your submission. Hey, I'm just wondering if, there's been a lot of talk about sovereignty, cessation, yes, no, the other thing. But internationally, if we really get down to it, if there's indifference in interpretation of the two treaties that our country deals with, then through a act of international treaty law called contra preferendum, the indigenous language version wins out. So I'm just wondering if you can point out for me in the Māori text of Te Tiriti o Waitangi where Māori cede their sovereignty.
I think the easier way to do it is just to simply say, could you point out to me at what point Tamati Wakanini did not understand the ceding of sovereignty?
The text is the text. The text is the text. It's what we have to deal with. Sorry, the text is the text. So it's what we have to deal with.
He signed the text.
People said a lot of things, but I'm just asking you if it's in there in the Māori text somewhere.
I would have thought clause 1's clear enough for you using the Kawharewa translation.
Or just again in the Māori text, if you can point it out, that'd be great.
I've just pointed it out with the Kawharewa translation.
Is that the Māori
You don't
text?
want to hear my I don't intend to speak to you in Maori. Wonderful language, but it's not something that I'm,
Okay, folks, is there any further questions for Paul?
No.
No, Paul, there's no further questions from the committee. Look, thank you for your time this afternoon and for providing your submission. We do appreciate you being with us and speaking to it.
Thank you.
I'm just going to move on now to from Paul Goldstone. So if Paul's in the room, he can come up to the table. Thank you, Paul. Welcome to the committee. We have you with us for 10 minutes this afternoon, so I'll hand over to you to begin your presentation.
Strangely sitting here instead of over there. Thank you, Mr. Chair, members of the committee, and particularly the committee staff who have been working very hard on this bill. I'm Paul Goldstone. I support this bill and recommend that it be passed. I will summarise my submission and then take questions. I was a specialist in 19th century New Zealand history. I've worked on treaty issues in various roles, including here at Parliament. I currently work in the private industry. Obviously, my statements are my own personal views. I wish to make 3 high-level points. First is that the definition of treaty principles should be determined by Parliament. Treaty principles should not be some sacred mystery. Parliament should be able to clearly state what they are, given that Parliament created them. The concept of treaty principles was created by Parliament in 1975, but did not have any real effect until principles of the treaty were put into the SOE Bill in 1985. This was done by SOP at third reading without debate. As politicians, as MPs, I'm sure you have an understanding of what that really means. To the surprise of many MPs, in 1987, the Court of Appeal effectively interpreted this vague treaty principles to have an almost constitutional effect. Since then, Parliament has remained silent in defining the treaty principles it has somewhat haphazardly put into law, while the courts, the Waitangi Tribunal, public agencies and officials have somewhat enthusiastically sprouted various principles. What we have at the moment is that treaty principles are vague and are determined on an ad hoc basis by often unaccountable bodies, leaving important political questions up to judges and the bureaucracy. Is Parliament abrogating its core duty and is not tenable? Principles of the treaty should be determined democratically through Parliament. Second, defining treaty principles in law. There are currently anywhere from between 3 to 8 various inconsistent and ever-changing principles developed by various bodies, government officials, courts, and the Waitangi Tribunal. It was notable that when 2 MPs from the same party spoke out against this bill, they confidently espoused principles that were completely different from each other. This buffet of principles is nonetheless used by government officials to determine policy. Employees or professionals in various bodies are expected to have a commitment to the principles of the treaty, or must take into account the principles of the treaty in their work or various applications. The treaty principles, I believe, should be founded on a reasonable interpretation of the 3 clauses in the 2 texts of the treaty itself. Broadly, these are sovereignty / kawanatanga, protection of Maori rights / tino rangatiratanga, and that all New Zealanders have the same rights. I have some reservations about the exact wording in Clause 6, especially the second principle. I prefer the 1989 Labour government's articulation of principles, the principle of kawanatanga, the principle of rangatiratanga, and the principle of equality under the law. If the committee does not agree to these 3 principles, then what are the principles of the Treaty of Waitangi? I challenge members of the committee to put forward what they think are the principles based on a good faith interpretation of the 2 texts and put those into legislation. Third, I argue that defining treaty principles is inevitable when New Zealand becomes a republic. I appreciate that this committee will spike this bill. But when New Zealand becomes a republic, it will almost certainly be on the basis of, 1, that New Zealand is a sovereign republic by the will of the people, and that all New Zealanders as citizens have the same rights and are equal before the law. And of course, I expect as a process it will be ratified by a referendum. That is all. Thank you.
Thank you, Paul. We've got a number of questions in line. I'm going to go to Ginny Anderson, then Todd Stevenson, then Tammy Paul.
Thank you, Paul. I think I remember you from around this place when I worked here too, a while ago. Can you unpack for me where this argument, from your view, about judges not having a role in our democracy? They do that every day. We make the laws, they interpret the laws on a multitude of cases on a day-to-day basis. Where does the ACT Party or your views, where does that arrive from, that in this particular space, the courts don't have a role?
Courts have a role in interpreting law, but we're on fundamental political issues that should be dealt with by Parliament, who, after all, are the responsible for making those laws. The role of the judiciary is to simply interpret those laws. What we've seen, though, is that because of the vagueness of this term, you've seen judges in other bodies, in particular in the public sector, just simply stretch out what this means, that are unaccountable.
So your point is that they still are a part of our democracy, but they are restricted to simply interpretation
of the law. Yeah,
Thank you.
but law comes from Parliament.
Thank you, Jenny. Todd, and then Tim.
Thanks for your presentation. You said that the current principles, so not the ones in the bill, but the current principles are vague. Some other submitters have said they're conservative or benign, and then you've said there's 3 to 8 principles. I mean, what is the consequence of actually not getting some definition around these principles for the country going forward?
Well, you end up with just complete confusion ultimately. I mean, there are simply no set principles. This idea that there is an established body of law around treaty principles, you simply have to go online and see for yourself that it's continually changing. And in fact, the fact that 2 ex-senior ministers couldn't even articulate what treaty principles were consistently with each other is an indication of the fact there's just confusion. Now, when government bodies are being asked to make decisions, when people applying for positions are expected to explain a commitment to the principles of the treaty and so on, when actually it's a moving feast, that's just not good.
Thank you, Tim.
So Paul, my question is, in your submission, you've written to claim that anyone by accident of ancestry can enjoy special rights is repugnant in any democracy, you know the rest. What makes it so repugnant? Because there are heaps of democracies that have special rights, whether it's language, race, religion. So what's so repugnant about New Zealand doing what is actually quite normal in other democracies?
I don't think it is normal. I think in most democracies, it's pretty clear that you shouldn't have specific rights based on your ancestry.
But do you understand that other countries do have special rights based on things, not just race, also language and religion and a whole lot of other factors, that's normal?
I don't agree with that. I think in most Western democracies, it's a standard principle that your political rights, particularly political rights, are completely not related to your ancestry.
Okay, I'll send you some links.
Thank you. Any further questions? Tākata first.
Yeah, kia ora e hoa. Hey, I've just got a simple question. Do you think that Te Tiriti o Waitangi gives every person in this country the constitutional right to be here?
Yes, it creates the document that creates the government of New Zealand.
But does the constitutional right come from the treaty?
No, the treaty is the foundational document for creating the government of New Zealand.
But the constitutional right comes from the treaty.
Well, actually, the constitutional right for me to be a New Zealander is that I was born here.
Oh, I didn't say New Zealander. I said in the country.
Well, yes, if it's...
Kia ora, thank you.
Thank you, folks. That's the time for today. So, Paul, just thank you for your submission. Welcome back, albeit temporarily, maybe. And no, we appreciated your time here this afternoon.
Thank you very much.
We're going to move now to submission from Hobson's Pledge, and I understand we have Elliot Eke with us. Good, Elliot. Thank you for joining us. Welcome to the committee. You've got 10 minutes with us this afternoon, so I invite you to start your presentation.
Tēnā koe, tēnā koutou katoa. My name is Elliot Ewan Pasione Ikile, and this is my colleague, Thomas Newman. Hobson's Pledge is a civil rights group driven by 140,000 supporters who believe that all New Zealanders should be equal before the law, no matter their skin colour, no matter when they arrived in the country. We draw inspiration from the words of Governor Hobson during the treaty signing, which is he iwi tahi tātou, which is, of course, we are one people. We educate on treaty and related legal issues. We expose apartheid-style policies being quietly spread throughout the New Zealand system. We fight through various mediums, such as front pages of the New Zealand Herald, to stand up for equal rights and have fun in poking, often taxpayer-funded, bears of racism that we have seen expand and exponentiate, especially over the last decade. We receive requests from help up and down the country from many, many people in different industries. And this is even outside of the 140,000 people on our lists. Now, before moving into our commentary, we also want to bring up a public point here, which is we learned this morning that Hobson's Pledge had not been given a time to present. This is outrageous when you consider our leading voice and the tens of thousands who support us. We want to thank Democracy Action for giving us their spot that was done pre-hand, which was done beforehand. We were expecting to be given a voice on Thursday. That didn't happen. We also want to thank those staff members and the clerk for being able to confirm that we were indeed here as per Democracy Action's brave sacrifice. Again, Mr. Chair, it is incomprehensible that we would not have a voice to speak at. There are serious questions that need to be asked on that. Now, I'll pass over to my colleague in order to start that commentary process.
Thank you, Elliot. Mr. Chair, committee members, my name is Thomas Newman. I'm a practicing civil litigator in law based in Auckland. I'm a recent appointee trustee of Hobson's Pledge. I will be addressing you today on principles 1 and 3 of the Treaty Principles Bill. Elliot will be addressing you on Principle 2. Hobson's Pledge supports Principle 1 of the Treaty Principles Bill. Laws must be made by a sovereign entity. Sovereignty must be unified and laws applied equally to every person within a jurisdiction. Otherwise, they are not laws. The fact is that this Parliament is the sole sovereign of these lands. There is no other serious contender for sovereignty in New Zealand. It has this authority as a matter of political fact, but it continues to have sovereignty because it is a representative institution with members elected through free and fair elections. Sovereignty is derived from the people who are governed. Now, these facts are reflected in Principle 1 of the Treaty Principles Bill. Principle 1 acknowledges the right of the government of the day to govern, Parliament's authority to make laws. Now, these empowering elements are balanced by explicitly stated limits. Governance and lawmaking must be done in accordance with the rule of law and to maintain a free and democratic society. Principle 1, therefore, complements the New Zealand Bill of Rights Act 1990, which similarly acknowledges Parliament's sovereignty, but permits only such limits on protected rights as can be justified in a free and democratic society. Principle 1 is simple, elegant, and reflects constitutional orthodoxy and political reality. Some argue that it does not, which is one of the reasons why the Treaty Principles Bill is necessary. Principle 1 is not, or at least shouldn't be, controversial, so it should not stop the bill progressing to a referendum.
Principle 2 is critically flawed. It states, the Crown recognises the rights that Hapu and iwi had when they signed the treaty, Te Tiriti. The Crown will respect and protect those rights. Those rights differ from the rights everyone has a reasonable expectation of to enjoy only when they are specified in treaty settlements. Now that's effectively saying that New Zealand will treat all people equally, but not really. That is not equality. While we generally support the treaty settlement process, the committee must consider the following issues that will become present One, the exact agreed rights in 1840 are unclear and likely will remain so. This ambiguity will perpetuate conflict and litigation, and it will be taxpayer funded. I don't think there's a doubt about that. Existing treaty settlements contradict Principle 1. And number 3, many settlements are yet to be concluded. This is likely to create rights superior to those of other New Zealanders. And perhaps this is why we see in our culture, our workplaces, even today in many, not all, but many of our submissions today, an articulation of white guilt on one side and victimhood on the other side. These do not help our people. They do not help our nation. We need to get rid of them. As currently worded, Principle 2 invites the creation of laws based on differences by bloodline, making a mockery of Principles 1 and 3, indeed Articles 1 and 3 also of Te Tiriti o Waitangi. Hobson's pledge recommends that Principle 2 return to its original intention, simply guarantee the property rights of all, akin to Article 2 of the treaty itself. We are happy to now take any questions or...
Might need to address Principle 3. Turning now to Principle 3. So Hobson's pledge supports Principle 3. There's a qualification there which I'll turn to a little bit later on. But this principle states that everyone is equal before the law, entitled to equal protection and benefit of the law, and has the same fundamental human rights. Things like affirmative action in health and education, co-governance in central and local government, or privileged access to power through consultation obligations are said to be justified by the treaty. This violates the principle of equality. Now, I'd just like to make a note here on consultation. Many submitters have complained that Maori have not been consulted on this bill. This is demonstrably false. Many of the submitters today, and presumably in future hearings, are Maori or Maori groups, and being Maori did not disqualify any of them from participating in this process. This is a consultative process. Many submitters have made historical and legal arguments based on the treaty why we should have all of the things that I referred to earlier. They pay lip service to Principle 3, to equality, saying that it is already a part of our law in one breath, while attempting to justify different treatment in the other. Not only are these arguments incoherent, they are distractions. No technical knowledge of any sort is required to understand that different rights for different people, especially on the basis of race, ancestry, or belonging to some imagined separate polity, is a recipe for disharmony and resentment. It is also simply wrong. Equality is essential to a harmonious and just society. It does not require that people be the same, value the same things, or frankly, even like each other. Free and equal people in a democratic society are allowed to be different, to value different things, and to lead different lives. Understanding this should deal with much of the fear that people have about what the passage of this bill would mean. I'd like to now turn to the one qualification we have to our support for Principle 3, the use of the phrase equal benefit. We're concerned that the inclusion of this phrase in Principle 3 as currently articulated would introduce the concept of equity or substantive equality. We would remove this phrase from Principle 3. Sovereign Parliament can and does legislate to address material inequality, but it should not be a constitutional guarantee or principle. Now, just very quickly in closing, and I realise there's probably not going to be much time for questions, but I'd like to just say, there's some phrases and words, ways that people get identified in conversations of this sort. One of them is Pākehā, another is European. Well, I'm neither of those things. I'm not my ancestors. I was born here. I'm an individual. I'm a New Zealander, and I don't think it helps to talk really in any other way than that. My rights in this place, to address Mr. Ferris's question earlier, don't depend on a document signed in 1840. And frankly, the suggestion that they do is wrong. Thank you.
Thank you, Elliot. Thank you, Thomas. I'll just sort of clear up a perceived misunderstanding. Hobson's pledge was invited in the first emails that went out to make a submission, and unfortunately they weren't able to respond by the deadline, and so those slots were filled up by those submitters who did respond in time.
It's possible
But
we have a
it
severe
is
miscommunication.
very good to
We've been
have you
very
guys
much
here,
on
and
to it at
we
every point.
appreciate the time that you spent with us this afternoon. So thank you.
Special treatment.
Folks, we're going to move on now. That's the end
Thank
of
you,
the
Mr.
time for that session. We're going to move to a submission now from Rangitane or Wairau. And with us is Corey Hibbert, who's the General Manager. Good, Corey. Thank you for being with us. We've got 10 minutes on the clock today, so I'll hand over to you to present your submission.
Tani whetu ki te rangi, ko Rangitane ki te whenua, tēnā koutou ngā mema o te komiti parimata, ko Corey Hibbert tōku ingoa, he uri ahau no Rangitane o Wairau. I'm here today on behalf of Rangitane o Wairau to oppose the Treaty Principles Bill in its entirety. I'm joined by the co-chair of our Rangitane o Wairau Settlement Trust, Janice Deferi. We're grateful for the opportunity to present orally to the Select Committee, especially given that there will be thousands who will not have that opportunity despite asking for it. Before I begin, I want to acknowledge you, Mr. Chair, and your recent appointment as Minister for Te Waipounamu. You have already outlined a strong focus on advocating for Te Waipounamu and driving economic outcomes for the mainland. Rangitane is one of the 9 iwi of Te Waipounamu looks forward to supporting you and seeing you succeed in your role. When whānau Māori in Te Waipounamu thrive, all of Te Waipounamu thrives, and when Te Waipounamu thrives, Aotearoa thrives. Also want to acknowledge our local MPs, Takuta, Rachel and Jamie, tēnā koutou. But to the matter before us, the Treaty Principles Bill, let me state our position very clearly. We oppose this bill. This bill is a step backwards for Aotearoa. It undermines decades of progress and threatens the very foundation of our nation's identity and constitutional framework. Te Tiriti o Waitangi is a living covenant between Tangata Whenua and the Crown, a promise to work together for the benefit of all people in Aotearoa. For decades, iwi like Rangitane have worked tirelessly to uphold that promise and to rebuild what was lost through raupatu, treaty breaches and dishonourable Crown practices. Our 2014 settlement was a significant milestone for us, but it was not the conclusion of our journey. Settlements are not the full expression of Māori rights. They are simply a step towards restoring some balance. Through our settlement, the Crown committed to re-establishing a relationship with us. To quote, be one that was based on mutual trust, cooperation and respect for the Treaty of Waitangi and its principles. Yet here we are, addressing a government bill that seeks to redefine those very principles. This bill violates Article 2 of Te Tiriti, which guarantees tino rangatiratanga over our lands, taonga and resources. And the attempt to restrict treaty principles merely to historical settlements disregards the spirit and intent of Te Tiriti. It is an affront to Mai Tupuna Ihaya Kaikoura, who signed Te Tiriti o Waitangi at Horahura Kākahu in the Port Underwood on 17th of June 1840. The exclusion of tangata whenua from meaningful consultation during the drafting of this bill is, frankly, an egregious breach of good faith on the part of the Crown. How can a bill that profoundly impacts Māori be introduced without the input of those who it most affects? This legislation has been made about us, but without us. Where is the mutual trust and cooperation in that? Te Tiriti o Waitangi is Aotearoa's foundational document. Its principles are woven into legislation and they serve as a cornerstone of our constitutional framework. Attempting to narrow and redefine those principles undermines that foundation, leaving it cracked and unstable. By removing the judiciary's ability to interpret treaty principles, this bill attempts to consolidate power within Parliament and the Executive, and it weakens the checks and balances that have upheld the Crown-Māori relationship for decades. If passed, this bill will have profound and long-lasting consequences for Māori. It perpetuates inequity, it undermines trust, and it risks further alienation of tangata whenua on the whenua. As the Waitangi Tribunal has stated, this bill represents one of the most significant breaches of Te Tiriti in modern history. Rangitane urges this committee to recommend the withdrawal of this bill in its entirety. We are not opposed to a meaningful kōrero about the place and the role of Te Tiriti in Aotearoa's future, but this is not that process. Te Tiriti is a document, yes, but it is more than that. It is a promise and a commitment to work together. And it is one that has been reaffirmed through decades of legal precedents grassroots advocacy, and Crown Māori partnership. So to this government and to this committee, Rangitane asks you this: history will judge you. Will you be remembered as those who honoured the promise of Te Tiriti, or as those who tore it apart? And with those remarks, I'll leave the remaining time available for any questions that you may have.
Kia ora, Corey. It's very good to see you before the committee again. You've got two of your local MPs that would like to ask you a question, and rather than have a scrap, we'll go to the first in time and ask Rachel Boyack to ask you a question.
Thank you, Mr. Chair. Kia ora, Corey and Janice. Lovely to see you here today. My question is around your Settlement Act from 2014, I believe it was. You mentioned in your kōrero that the agreement actually references the principles of the Treaty of Waitangi. So I'm really interested in your views on how this bill, if it were to proceed, would potentially undermine your settlement. Maybe some practical examples of how that would undermine things or potentially be in conflict with your settlement, because it specifically references the principles. So if those principles get amended, what's going to be the impact for your settlement and how it plays out going forward?
Yeah, that's right. So the deed of settlement that we signed with the Crown in December 2010 included the apology from the Crown, and that apology is lengthy. And it was hard earned to get that settlement, but also to get that apology from the Crown. What I would say is that it does mention principles, but more particularly it references respect and mutual trust, cooperation. This bill is about more than just undermining the principles, but it undermines Te Tiriti itself. It undermines the relationship. It undermines the value of that settlement, because it directly goes against what we have entered into in good faith. What I would say in terms of the second part of your question, some practical examples of where this might come into play, is simple processes like working on legislation like this, having the opportunity to kōrero, to have mutual trust and respect with one another, with those who represent the Crown at the time. Yeah.
Kia ora, Corey. Thank you. Tangata Ferris.
Kei aku whanaunga tēnā kōrua Janice, tēnā rawa atu ki a koe Corey, kōrua tahi. My question is more around te ohanga. To the chair, Mr. Meager, welcome to looking after the whole of Te Waipounamu e hoa. Look, like it or not, Tiwi Māori throughout Te Waipounamu are a significant player today in its economy and one of the biggest and fastest growing into the future. It doesn't matter where you stand politically or whatever, that's the reality. And iwi have been very patient and gracious in dealing with the Crown over the last 10 to 15 years as they moved through settlements, but they now have in their hands significant resources, significant cash assets, and it's really dependent on a good relationship with the Tiriti partner and its government. So my question for you is, how does this current action and direction of this government, given they have such a firm focus, a laser focus, ruthless focus on getting the economy back on track, how does that make you feel working with them into the future?
Tēnā koe te whanaunga, nā mihi. So what I would say, firstly, around the economic value of the settlement, I fondly remember working closely with Mark Solomon through our asset holding company several years ago. And Mark spoke of the value of treaty settlements relative to the loss that had been quantified. So we're talking about a 1% settlement value against what was lost. Anyway, we're moving forward and we are working hard now to re-establish ourselves, and that has provided us with that basis to do that. How does it make us feel in terms of working with the Crown? Well, in many respects, the treaty forces us to work with the Crown. That is the nature of the relationship that we are in, and Rangitane will work with whoever it needs to work with at the time. But we will also stand on our own 2 feet. We will be providing opportunities for our people, and we'll be using the settlement base that we have to start with for now to build a better future for them, and certainly one that is better than the likes of my grandparents and those before them inherited.
Oh, kia ora, Corey. There's not time to squeeze one quick question.
A very quick question, which we just need a quick answer, which is the previous submitter noted their views around equal rights. One of the things we know in Aotearoa is that Māori have significantly lower life expectancy of around 7 years for both male and female. In your view, does that represent equality?
Absolutely not, and that's just the start. You could go to poorer cancer outcomes, hospitalisations at higher rates, especially for respiratory diseases, higher rates of homelessness, higher rates of unemployment. Where to start?
Kia ora, Corey. Thank you. Thanks for being with us today and for spending the time here this afternoon. We appreciate it. We're going to go to submission now from Marilyn Waring, and Marilyn's going to join us online.
Tēnā koutou katoa.
Kia ora, Marilyn. We can. If you can turn your video on, if that's possible, we'd appreciate that. Thank you and welcome to the committee. You're relatively familiar with how this process works, so I'll hand straight over to you for your 10-minute submission.
Thank you, Mr. Chairman. Tēnā koutou katoa. I'm going to take just a couple of moments to expand on the opening comments in my submission on equality and rights. So in the general policy statement, we're advised that the bill wishes to create a conception of each person's rights within our constitutional arrangements. Well, fundamental to our undergraduate studies in our university is to learn that different cultures have different concepts of ideas. So I don't really know, I've no idea what create a conception for all people might mean, but it's clear in Clause 6, Principle 3 of the bill, that formal equality means everybody gets treated according to the values of the dominant group in society, because that's always what formal equality has meant and does mean. But the meaning of equality is so highly contested that there's no universal agreement as to what it means. And this bill is based on the old approach, the pretense that everybody's born equal and that people can have the same treatment regardless of differences, and that's equality. Well, you might meet this approach in a history of ideas course, in an undergraduate philosophy course. That's where you find Aristotle and Plato. But thankfully, we've moved on from the formal equality conceit. Then there's this issue of concepts. Concepts are hugely varied in their meaning and interpretation, and they're subject to paradigm shifts. I'm kind of had my breath taken away this morning and this afternoon listening to people, as if codifying something into law means that time stands still. One of the reasons we have the judiciary is to take account of the fact that Parliament never keeps up, and Parliament especially never keeps up when it's about people's rights. And the Minister this morning reiterated that the bill is his belief. Well, beliefs and concepts are what we call ontological and epistemological. Like, how do we know what we know? So they're constantly in motion. And what one man's ontology and epistemology mean to him is not a basis for constitutional change. In Clause 4 of the bill, there's no definition of the key terms equality and rights. So the bill appears to take for granted that equality and rights is the same old we are all born equal rubbish. So there are two key points to be made. Key features of the treaty are the rights of hapu and iwi Māori, that is collective rights, referred to in Principle 2, but in Principle 3 is entirely singular. There is no space for class actions or collective rights. And the bill reiterates this singularity. Everyone is entitled to the equal protection, equal benefit of the law, equal enjoyment for individuals of the same fundamental rights. Well, protections and benefits and enjoyments are static words on a page. If you're interested in equality and rights, the foci are outcomes and results. So what should equal protection, benefit, enjoyment mean? Well, whatever Hobson's choice say, fortunately, Western democracies have embraced and recognised the practice of substantive equality. And substantive equality is not a concept. It's an analytical framework. Now, where a person or peoples have been subject to socially constructed, historic, systemic and systematic, accumulative disadvantage, equality cannot be achieved through equal treatment. And there can be no question but that iwi and hapu in Aotearoa have been subject to socially constructed, historic, systemic and accumulative disadvantage. You address this through substantive equality, through equality of outcomes and equality of results. And for an earlier person this morning who wanted to know, where's substantive equality work? Well, it aims to change and transform discriminatory practices. There are plenty of examples of its use in the European Union, the European Court of Justice, the Supreme Court of Canada, acting on their Bill of Rights, the South African Constitutional Court. Substantive equality is about redressing disadvantage. It's about addressing stigma, stereotyping, prejudice. It's about enhancing voice and participation, and about accommodating difference and achieving structural change. Substantive equality aims to change and transform systemic discriminatory practices. Equality is never achieved through equal treatment. Thank you, Mr. Chairman, for the opportunity to expand on my submission. There may be questions.
Thank you, Marilyn. We've got two questions to start with, first from Duncan Webb and then Ginny Anderson.
Kia ora, Professor Waring. Can I just say how much I enjoyed reading your submission? And you draw a direct line from your own family story, from the Tainui Wars to the present day, and then close by saying if we don't learn from history, we're doomed to repeat it. One of my concerns in this discussion we're having is that people are looking at things in a very short time span. They think of, the 1980s and beyond. And I guess I'm just inviting you to talk to that part of your submission and how where we are today is affected by, where your family was 150 years ago.
Yeah, well, one set of my great-grandparents was married by Reverend Ashby, who was set up the mission station at Kotatehi, where Te Wherewhero's pa was. So in 4 generations of my family have farmed and owned lands in Taupiri and Komakarau, and then other parts of the Waikato. But the principal family farms were established because Waikato Tainui had to desert their lands and run south of the Punui River. And I've never forgotten that. And I had a message from my brother the other day, just saying, go sis. And he was saying, we've watched our families bear the fruits of decades of subsidies in farming, and then the decades of profit from there not being a property speculation tax. And we watch how those generations have talked about that, and they never want to remember. They never want to remember that many people were murdered, exploited, disenfranchised, so that those families could be successful.
Thank you, Dr. Webb. Dr. Waring will go. Ginny Anderson.
Thank you very much for submitting, and thank you again for your submission. We've heard today a lot about equality and the importance of equality and everyone having equal rights. I'm interested on your view of what happens when that version of equality negates someone's identity. What happens to New Zealand when that plays out?
Well, I think we go backwards in terms of you know, the decades of some forms of progress that have been made in my lifetime. While I think one of the very best examples of the reasons for substantive equality are te iwi Māori, they're obviously the same for women, you know, for those with disabilities, for children who still substantially don't have a voice. If it wasn't for substantive equality, there are a whole range of legislation in New Zealand that simply would not have proceeded. I know it's only sort of one class of people, but matrimonial property, for example, the kinds of different health policies that must be made for women, you know, whether it's around pregnancy, maternity, menstruation, a lifetime of submitting to superannuation schemes to then find you're still tens of thousands of dollars behind men because there was pay inequities. So we're surrounded by substantive equality and the challenges of it all the time. For those who are
Sorry, Dr. Waring, I'm very sorry to interrupt, but that is the time for us allocated today. So can I just acknowledge your submission and thank you on behalf of the committee for being with us today. We do appreciate you being here.
Thank you.
Kia ora, thank you.
So we're now going to invite Professor Jane Kelsey up to the table. Thank you, Jane. Thank you for being with us. I think you two are also familiar with the process, so I will invite you to present your submission for the next 10 minutes.
Kia ora, thank you. Can I speak to you in two capacities? One is someone who spent over 4 decades as a legal academic and researcher on Te Reo Waitangi policy, focusing in particular on areas of treaty principles, which included my PhD thesis, a number of books, and evidence to a significant number of Waitangi Tribunal hearings, including most recently the treaty principles one. But my second capacity, and this kind of follows from what Marilyn Waring was saying, is as a Pākehā who in Aotearoa believes that we cannot cut ourselves adrift from the foundations on which we and our tupuna were here. And in my case, like Marilyn, my mother's whānau come from a place called Sentry Hill in Taranaki. And I always used to teach my students what Sentry Hill actually was about and for. And so I think those personal stories are very important in us understanding the implications of what this bill tries to do. Secondly, I have also been asked to make a point to the tribunal that there are many people, especially many Māori, who have put together submissions on this bill, some of whom took flights down to Wellington with sheaths of submissions to get them in here when the website fell over, and who are expecting that their voices will be heard. And so I was asked to bring that before the committee. The committee itself, the bill itself and the explanatory note identify 4 objectives, and I have no particular problem with the objectives. One is greater certainty and clarity. A second is a more robust and widely understood conception of constitutional arrangements. The third is to build consensus around te tiriti and constitutional arrangements to promote greater legitimacy and social cohesion. And fourthly, to promote a national conversation. What I do have a problem with is the provocative way in which that has been proceeded with through this bill that has caused very considerable harm. And I heard that especially during the Waitangi Tribunal hearings and subsequently to that. The proper place for that conversation is in the Constitutional Kaupapa Inquiry that is now underway in the Waitangi Tribunal. And I would invite the Parliament to endorse and the committee to endorse that as the appropriate forum in which to work out how we move forward. I have a different approach from a number of those who have made submissions, and it comes out of my many years of research, which is that I have a problem with the notion of treaty principles themselves. And I remember in 1990 at Waitangi, when Bishop Whakahuipi Thurko said to Labour, "We do not need your principles. We have te tiriti." And my own research, especially in my very lengthy PhD thesis, looked at and traced through the construction of the notion of principles of the treaty in the 1980s, and which brought into the light what ngā tamatoa in their 1974 submission on the Treaty of Waitangi bill said. You talk in this bill about treaty principles, but whose principles and who is going to define them? And so the research I did in the 1980s in particular showed how quite cynically the concept of the principles had been constructed. And there was reference earlier to the principles for Crown action on the treaty in 1989. I got leaked a whole series of documents whilst they were being constructed by those who were uncomfortable in doing it, because they were basically asked to rewrite Te Tiriti o Waitangi through Crown principles. So to me, this Act Bill is a logical extension of those attempts to bypass the realities of what are in Te Tiriti o Waitangi and substitutes them with something that the Crown can be comfortable with. And in my submission, I quote, for example, Sir Robin Cook before the Lands case, saying the Treaty of Waitangi can't really pass muster as a document to take seriously today. And then describing his principles in the Lands case as being a subtle constitutional repositioning, which David Longy repeated in 1990 at the Commonwealth Law Conference in Auckland. And so we need to actually put aside this principles as a vehicle through which we have been avoiding having the constitutional conversation around Te Tiriti o Waitangi. Let me just make two further points. The issue about the referendum. It was extremely concerning in the Waitangi Tribunal to hear that the officials have been asked in parallel to this process to be working on implementation of a referendum approach on this bill. Now, we hear this bill is not going to proceed, but that doesn't mean a citizens-initiated referendum cannot be instituted and an attempt to have that at the time of the next election. And already the cogs are moving in that direction. That is a major problem. The second is that even if this bill fails, as we've been told it will, the Regulatory Standards Bill, promoted by the same minister in a manner that has been completely antithetical to what are supposedly best practice regulatory approaches, would effectively write Te Tiriti o Waitangi out of the priorities in the lawmaking processes. And so I think you will expect to find there is an equivalent move on that occurs irrespective of what happens with this bill. And the coalition agreement, unlike this, which says taking this bill to select committee, although David Seymour's remit is and passing it, the Regulatory Standards Bill is to be legislated. And so I invite the select committee to seriously consider the implications of that for Te Tiriti o Waitangi. Kia ora.
Thank you, Professor Kelsey. We've got two questions lined up. First from Duncan Webb, then Mariamino Kapkingi.
Kia ora, Professor, and thank you very much for that submission and all the work you've done. I'm interested in the discussion you had around, your lack of enthusiasm for principles, full stop. And I guess how we approach what the treaty means today and how we apply it to real world situations needs some tools, right? And I guess the principles might be a useful shorthand for those tools. But I'm interested in your comment and your thoughts on how we actually approach the kind of changing obligations under the treaty today due to changing social and wider circumstances if we don't have principles.
I don't understand why you need to have principles. You have very clear concepts from my understanding of Te Tiriti o Waitangi, and I've had the privilege of being tutored by people like Rob Cooper from Ngāti Hine in what that actually means. And if we look at the core value structures that underpin that, if we look at manaakitanga, if we look at whanaungatanga, if we look at kaitiakitanga, we can actually see in practice how that plays out. And so I don't see why we need principles to get us to that point.
Thank you, Jane. We'll finish with Marimino.
Thank you, Mr. Chair. So why do you think? So, because I can hear all your expertise mentioning Rob, that's a neat thing straight away. So what do you think is behind this noise and this distraction, if I can say that?
I think it is actually a political stunt that is about political opportunism and the fact that there is this disingenuous approach of the same minister to regulatory responsibility and to treaty principles suggests that he himself doesn't actually have principles. And we have in the academic other hat I wear about principles-based regulation, we say it only works if those who are involved in regulation have principles.
Thank you, folks. That's the time we've got for this afternoon. So can I just acknowledge your submission today, Professor, and thank you for spending the time with us.
Kia ora.
We've got our next submission coming to us online. We have Ngā Waihua o Paerangi, Ngāti Rangi, and Helen Leahy will be joining us. Helen, good afternoon. Thank you for being with us. Just doing a little bit of clock resetting. Stand by. Thank you for joining us. We've got you for 10 minutes this afternoon, so if you present your submission now, we'd appreciate that.
O tēnā koutou katoa. Ko Helen Leigh taku ingoa, I'm Tangata Tiriti. This is a term coined by Sir Edward Tauhakure during 1989 when he was chair of the Waitangi Tribunal. He referred to non-Māori as Tangata Tiriti, those who belong to the land by right of Te Tiriti o Waitangi. And he noted that without the treaty, they wouldn't have a lawful presence in such numbers nor any legitimate political role. My partner is of Ngāti Rangi, Tangata Whenua, people of the land, and together we have 4 children, all of Ngāti Rangi Waikapapa. While my ancestors come from France, Germany, Scotland, Orkney Isles, our children know that culture, know that history, but we choose to live in this land, and that choice brings with it responsibilities and obligations. This land is based on a covenant by which the first people, the people of the land, Tangata Whenua, negotiated with the Crown, the model for a unified nation. I give that background firstly because I believe that like a relationship, a personal relationship, that Te Tangata Tiriti, that Te Tiriti o Waitangi is a living document that is fundamental to the way that we live our lives, both personally, professionally, politically, and publicly. And so, speaking on behalf of Ngā Waihua o Paerangi, you will have seen in the submission our 4 principles that guided our settlement to uphold the spirit of the treaty. Where the Crown goes, so too does Ngāti Rangi, acknowledging the mana motuhake of Ngāti Rangi and the restoration of a cultural, economic, familial, environmental, social base. So why are we so concerned to oppose this bill? We believe that the treaty settlement followed decades of advocacy and action by our whānau, many not here to enjoy the fruits of their work. And we are doing all we can to meet those obligations. But as part of that, the principles of their participation were that Ngāti Rangi would live longer, healthier, more independent lives, a 1,000-year plan, if you like. Te Tiriti o Waitangi obligations and principles underpin our approach to wānau ora. They underpin the way in which we do our work every day. And so the principles by which our organisation bases our contribution to the community, the economy and the wider nation is about mana waka haere. So we are stewards as tangata tiaki over health and well-being of our people. Mana motuhaki, Māori self-determination, exercising authority. Mana tangata, the principle of equity, that the Crown has to commit to achieving health outcomes for Māori and contributing to Māori wellness. And mana Māori, the principle of active participation, active protection, ensuring that Māori can live as Māori, as well as the principle of options, requiring the Crown to provide for and properly resource kaupapa Māori. Over the last 25 years, since the introduction by the late Dame Tariana Turia of He Korowai Oranga, my work, the work of thousands of hauora providers, iwi entities, Māori organisations, has been guided by these principles. They acknowledge the engagement, the design, the delivery of Māori as being co-designers with the Crown, not consulted after the event. Those principles dictate our terms of engagement, just as the principles by which my partner and I negotiate our relationship based on living in this land, so too is every aspect of our work. And yet what the Tribunal found with this bill, and in particular the approval of Principle 2 under the Seymour Bill, was that it was an outright breach of the principles of rangatiratanga, kāwanatanga, partnership and active protection. I know that you want some time for questions. I wanted to bring wānau ora into this debate in respect of the late Dame Tariana, but also that her life was about ensuring that we could thrive through the protection of Māori well-being, of the right to equity for Māori and health outcomes, and that Māori participation is absolutely critical into ensuring long-living, thriving wānau. Political manipulation of our base covenant shouldn't be misused as a party political manifesto designed to capture votes. The exorbitant cost of this exercise, the disruption of goodwill, the ridiculous sham of exposing the nation to a bill that was pronounced dead months before the call for public submissions is inexplicable. We have to move forward as a nation, honour the promises made by all our ancestors, correct injustices of the past if we are to lay the groundwork for an equitable future. Kia ora.
Kia ora, Helen. Thank you for your submission. I hope for the sake of your relationship, you don't need the court to interpret the terms of your partnership, but we'll go to some questions now. We'll start with Debbie Ngarewa-Packer, then Todd, and then Steve.
Tēnā koe te tia mana. A tuatahi ngā mihi kei a koe te tuakana, a ngā mihi te wā pauri mō tā tātou whanaturia a hoki. My question to you is, and acknowledge all the mahi and the moemoeā of Ngāti Rangi, why do you think this bill, the Treaty Principles Bill, has been kept alive for 6 months?
My view is that it distracts us from the other 28 pieces of legislation where the treaty principles are going to be deleted. My view is that this has been a costly exercise which spearheads and galvanises the action of Māori against this bill. But in the meantime, there are so many other bills that require close scrutiny, oranga tamariki, the work around the resource management, the conservation estate. And so that's my particular perspective, that the bill has been kept alive and in an effort to reduce the spotlight on some of the other legislation.
Thank you, Helen. A question from Todd, then Steve.
Yeah, and thank you for your presentation this afternoon. I just want to go to pages 6 and 7 of your submission. I want to thank you for actually going through the causes of the bill and actually having a response. Just in regards to Principle 3, or might be regarded as clause or Article 3 of the treaty, what do you think that principle should be, or how do you think that article should be reflected? Because you say it has no resemblance, but you don't actually go on to say what you think it should say.
Because my basic tenet is that we don't need to redefine what already is determined by the way in which we do our work, that the current principles is defined by the Waitangi Tribunal, defined by the court, and the articles of the treaty embody the spirit of partnership that we believe is enmeshed in that notion of active participation, protection, and partnership. So I didn't want to provide a contrary verse because I already believe that we have it.
Thank you, thank you, Todd and Steve.
Yeah, thank you for your submission. Your quotes in your Ngāti Rangi deed of settlement, the Crown apology that it is sincerely remorseful that it is not treating Ngāti Rangi as the friend and ally you have always been. For all of the harm this has done to your sacred connection with Mātua Te Mana and the waterways of your rohi, the Crown unreservedly apologises. Above all, it is with profound remorse that the Crown admits that it has not honoured Ngāti Rangi's partnership with the Crown under Te Tiriti o Waitangi. And with respect and integrity that you deserve, the Crown humbly apologises. How do you feel that the acts of this Parliament and this government presently are consistent with the authenticity, supposedly, of that apology?
It is not consistent with a meaningful and effective apology. I believe the courts have referred to the treaty as an embryo. It's rather than a fixed set of ideas that we continue to develop it, to discuss it in relation to the changing circumstances of our life. And that withstands the vagaries of time. It withstands political opportunism. But we can't do that if we don't keep to a full and final settlement, which is the words of the settlement. The apology had to mean something. We believed it meant everything that you have said, that you repeated to us, that direct apology for the past failings shouldn't open our government up to another episode.
Thank you.
Thank you, Steve. Thank you, Helen. That's the end of the time for the submission this afternoon. Thank you for being with us and speaking to us. We do appreciate you spending the time.
Thank you. Kia ora.
Folks, we're going to go now to submission from the Honourable Andrew Little. So I'll invite Mr. Little up to the room. I didn't recognise him. He looked like a young man. I don't know what this is about Parliament, but Mr. Little, thank you for joining us. You're very familiar with the process, so I'll hand over to you for the next 10 minutes.
Yeah, kia ora tātou katoa. Good afternoon, everybody. Thank you for the opportunity to submit. I do acknowledge that it is a great honour, given the 300,000 submissions that you will be no doubt diligently considering over the next few months, to have the opportunity to speak to my submission. Can I also say just an acknowledgement of some of the more recent discourse that this exercise is unimportant. I just reflect on some of the words that were spoken at Aotearoa on Friday, that too much is being made of this. I don't agree with that. The political judgment has been made to bring this legislation to the House, and notwithstanding the so far majority commitments that it won't survive a second reading, nevertheless, you have several months of work ahead of you as committee members to consider submissions and to hear from no doubt hundreds of people. And you have a second reading debate to go through as well. So this is an important debate. What people say and the sort of collective understanding amongst the nation about the treaty is, I think, going to be very important. I think this time will end up being an important touchstone in our nation building journey. So I acknowledge the work ahead of you, each of you, and ahead of you collectively as a committee, and indeed of this Parliament, and say that your task is an important one. I've kept my written submission as brief as I could. There's only one other point I'd really like to make, somewhat draws on the points made in my submission. And that again is a response to some of the public commentary that has been around for a while, but it's been sort of elevated more recently by sponsors and supporters of the bill, that somehow this bill acts to rectify or correct the fact that there are not equal rights for all New Zealanders in Aotearoa, New Zealand. And in fact, if you look at the ACT Party website and the special website they've set up on treaty issues, they use that language, that not everybody is treated equally. The point I want to make is that those comments imply or assume that rights are not presently equal or not equally enforced or upheld and that the treaty represents a source of inequality. And I just want to say that must be totally rejected. The treaty, if it represents anything, is a recognition of pre-existing rights, the pre-existing rights and interests of Māori and the promised protection of them. And the journey we've been on is not only to see a wholesale and egregious breach of those rights over decades and decades, but in the last 50 or so years, the journey of reconciliation and restoration, as we come to understand the treaty, its importance, the fact that it was breached, and that there must be some redress. Correcting wrongs does not create inequality. It restores the situation to what it was or should have been. To deny the ability to uphold the terms of the treaty would itself be an act of inequality, and it would make treaty rights secondary or inferior to any other legal rights, and would therefore make Māori unequal before the law. To the extent that this bill claims to address that, it is not addressing anything at all. And it's for that reason that my preference would be to see the bill not continue. So those are the remarks I want to make. I'm happy to take questions now.
Thank you, Andrew. We'll start with questions. We'll go first from Dr. Webb, then Debbie Ngārewa-Packer, then Glenn.
Kia ora, and good to see you, Andrew. Thanks for your submission. You kind of headline with your role as Treaty Negotiations Minister, but you're also Minister of Health, amongst other things. I'm really actually quite interested for a perspective from you as a minister as to how the treaty assisted you in managing the kind of conflicting demands on government, and making sure that essentially you did a good job for all New Zealanders, against the kind of background of the claim that you've just talked about, that giving treaty recognition of treaty rights is in some way unequal, and how you don't agree with that.
Yeah, I think any minister, I think in this day and age, knows that the treaty plays a fundamental role even in their day-to-day work. The right of kawana or kawanatanga is exercised alongside the rights of Māori under the treaty. Both are rights reflected in the treaty. So a minister must conduct themselves in a way that is consistent with the treaty and the Crown's obligations under the treaty. And I think I don't think I'm different to any minister, indeed a lot of ministers from a range of governments over the last 30 odd years that have sought to do that. We know when we look at public services, the services the Crown takes responsibility for, and health is foremost amongst them, that the achievements of those public services for the people of New Zealand is different depending on who you are, sometimes where you live. And we know that for Māori, health outcomes have been abominable, certainly on average considerably less than for the rest of the population. So a minister considering their obligations under the treaty will be thinking about Māori and their health as a taonga that has to be, that the Crown has a responsibility to protect, and will be thinking about tino rangatira and how Māori can provide leadership for better health outcomes. And that was what we sought to achieve in our, amongst many other things, in our health reforms.
Yeah.
Thank
Kia
you,
ora, thank you for that.
We'll go to a question now from Debbie Ngārewa-Packer,
Thank
and then we'll
you,
go Glenn.
Timana. Kia ora,
Kia ora,
good to
Dee.
see you here. I want to draw on, and we've had a lot of submitters, really great kōrero about the legality, the framework of Te Tiriti. I'd like to delve into your experience on reconciling with iwi whose natural development was interfered with quite horrifically. And in that experience for the rest of Aotearoa, if you could share with us, did you sense any violence, any hatred, any non-love for their whole nationhood? And in that reconciliation, as you were trying to restore interrupted rights and obligations, what was your sense of the future and the sense of the spirit and the thinking of many of those hapu and iwi and looking forward?
I think the reflection I had was often, given the harm done to Māori, and not just, the land confiscation is pretty serious. Shooting and killing people is pretty serious too. Failing to provide protection, causing Māori have to leave their rohe, their areas that they whakapapa to in order to survive economically. Those are huge intrusions. I think what I reflected on was the extraordinary patience that Māori have shown. I think largely because of faith in the treaty, but also faith in the Crown. And if you think about the Māori's early relationship with the Crown, the pre-treaty relationship between Māori and the Crown, and Hongi Hiki visiting the UK, meeting King William IV, Māori's relationship with the British Crown, well predates any New Zealand representation of the Crown. And my sense was that it's Māori's faith ultimately in the Crown to deliver on the promise that it made in the treaty that held Māori together, focus on the objective of having a living treaty that was truly honoured. And so there was no sense of, splitting New Zealand asunder, far from it. It was recognising everybody's place in it. The place for Māori, as reflected in the treaty, and the place for all newcomers to Aotearoa, New Zealand as well. The treaty, in my view, is a unifying document. When understood and when its historical context is understood, and we should embrace it on those terms.
Thank you, Andrew. We probably have time for one quick question from Glenn.
Kia ora. Hi, Andrew. Ngāti Rangi called this a distraction. Jane Kelsey called this a political stunt. We're here because of a coalition agreement between ACT and National Party. What do you see the politics of this bill?
I prefer to not engage in. I've done my time in politics, thoroughly enjoyed every second of it. The political judgments of the day get made. It is what it is. I think what I hope I get to bring from the benefit of my knowledge and experience, particularly experience as a minister and as Minister of Treaty Waitangi negotiations, are some insights that help to understand the treaty and its place and the future of Aotearoa New Zealand under it.
Thank you, Andrew.
Thank you for your time.
Apologies, Steve, we couldn't get to that question, but thank you for the time this afternoon. We do appreciate your discussion. We're going to now invite to the table Tangata Whenua Social Workers Association who are with us in person. And I'm sorry, I don't have the names of the submitters, so if you can come to the table and then introduce yourselves, and we'll start your 10-minute submission.
Ahoia nora tuatahi me mihi katika. Agi tō tātou watu nei te rangi mōna mana ki tagau iha. Mai ki runga i a tātou tō wītahi. E whakahone re tia ki runga tō tātou ariki ki ngā waiho nei te pō. E noho mai nā i runga tāhu rewa tapu o nā mātua no tūpuna teira wa mai ki te mapapa. Tu he tia pō te tau te whirowhiro te tuawhich. Hoia nora tēnei te iunga tu nei ki te wairua ngā mātua ngā tūpuna kia tau mai rā ki wainunu i a mātua i tēnei wā. Ki te whakarongo ake nei i ngā kōrero o raranga hia nei te tini te mana. O rira ki wairua mai rā puta. E mihi ka tika ki ngā mate tari ana tō tātou kingi, ko re rawe mutu ngā tangi mō rāwatahi, mō rātu katoa ko whetu rangitia. Whai anō rānei rā mātu ko tai mai rā kei moi te aroaro o koutou. Iuna atu nei ki o koutou tarenga ki te whakarunga i ngā wairua o tēnei kōrero ko rere haere atu ana. Uri rānei rā mātou e mihi atu ana ki a koutou, huri no tēnā putau, tēnā koutou, tēnā tātou katoa.
Nā whakamoe me te whakawheta e ue, ngō au mana ki tanga ki te wi e tau nei, ko koe te piringa ka puta ki te oranga e te ariki pai Māori e.
Koe anō rā kore rawe mutu ngā kupu po ko puta mai rā tō tātou kingi. Kia Māori tātou ia te rā.
I know.
Toi tū te tiriti o Waitangi, toi tū te mana mutu, te mana Māori mutu hake, orira tēnā tātou.
No, very much.
Tēnā koutou e nā rangatira. You will have read the contention presented by the Tangata Whenua Social Workers Association. I would just like to add a little kōrero before we open up the floor to pātai. The points of contention that the association would like to add to what has already been presented are as follows. The sovereignty of knowledge is often at the expense of the rangatiratanga of the whānau, tamariki, hapuri, hapu and iwi. The power of recognised qualification, predominantly tertiary, tends to marginalise the kotahitanga of collaboration and experience. Risk aversion, both as organisations and in practice, dominates the imperative nature of tiakitanga or custodianship. The determinant of perception undermines the sustainability of connection in uritanga. The association contends that the principles of the Treaty of Waitangi will exacerbate the points raised above, and for the profession and practice of social work, impede an effective delivery of service by the non-recognition of distinction, which then influences the potentiality of engagement of people and structures to address life challenges and enhance well-being. To diminish accountability both of organisational systems and competence in social work practice to navigate the uniqueness of difference and respect for diversities. The focus on averting risk marginalises the centrality of tiakitanga and oranga, therefore need to not meet either in longevity or in sustainability, thereby jeopardising the potential for social change and development. The paramountcy of perception will subjugate the uritanga of whānau, tamariki, hapuri, hapu, and iwi, and in this, the empowerment and liberation of people will be severely impacted upon and the promotion of social cohesion decimated. The association would like to leave the acronym as follows. Perception, the dominance of, accountability, the limitations of, and connection, the constraint of. And therein lies your acronym of PAC. Nō reira, tēnā koutou e tira Māori ora tātou.
Kia ora. Thank you for your submission. I'll take questions. The first is from Marimino Kapaki, and then we'll go to Duncan Webb.
Okay. Tēnā koutou nau mai haere maira, ki tō whare. Ko te pātai tuatahi. And so it's, you know, I'll just go straight in. How does this bill harm Māori social services and community development? You make quite a few points inside your submission, but that's probably the...
There's a wānanga in itself.
Yeah, no, pono.
I think the way it constrains, and I will talk about tangata whenua social workers in particular, is the language that is often utilised. And let me exemplify that by looking at the word culture, in my opinion, and certainly that of the associations. It limits the potentiality of language in that we're not talking about culture, we're talking about identity. So I think this is where, as has been referred by previous speakers, the limitation of culture already sets a tone which then inhibits the potentiality of practices tangata whenua social workers.
The second point that the association would add to that is the power of connection. So as tangata whenua social workers, we have the opportunity and indeed I would say the potentiality to connect. And that's both with whānau, tamariki, hapu, hapuri, etc. And I think that connection is often minimised by the perception of what is social work. And because social work comes from largely a tradition that is perhaps in some respects separated from us as tangata whenua, it in many ways limits what for us is the beauty and power of paukai, for argument's sake. So languaging and applicability of language can constrain practice and the perception of our discipline, in our opinion. Thank you.
Thank you. Question from Duncan Webb.
Kia ora karawa. Thank you for your submission. Look, I'm really interested in your expertise in the social work field. This bill seeks to reduce the treaty down to a kind of bundle of individual rights. Can you talk about your work as social workers and the importance of kind of communities, context, belonging, family, and histories, and how the treaty assists you in your work in kind of helping people through the situations they face?
If I may respectfully respond to your pātai, in that our work as tangata whenua social workers is not limited to the individual, that the individual has connections, and that's where the potency of uritanga becomes so pertinent, is that once you start as social workers unpacking what might be a referral to your service, you then start drawing connections to the trauma, to the mamaitanga, to the hurt, to the pain that has been threaded right throughout that whānau, and I would suggest, and we would suggest, generations before. I think this is where the limitation of connection and often diagnosis to that individual situation prohibits or indeed constrains the power of that connection. And if I may just briefly diverge for a while, we talk about te tiriti o Waitangi, but actually we go back as far as whakapūtanga. So the historical connection is what leads to the turbulence of today, which then generates what is to come. And I think it's that connection generationally that becomes really important for us as tangata whenua social workers.
Thank you. Look, I'm sorry to interrupt, but that's the end of the time allocated. Steve, I'll prioritise your next question. Thank you both for being with us and spending time this afternoon.
He mihi kia koutou. Kia ora.
We're now going to move to a submission from Brian Easton. If Brian's in the room, I'd like to invite him to the table. Thank you, Brian. Brian, thank you for being with us. We've got you for 10 minutes this afternoon, so I'll hand over to you to start your presentation.
Tēnā koutou, katoa. Apologies for the limitations of my voice. It's a consequence of surgery on the larynx. My written submission focuses on two elements of the Treaty Principles Bill, which insufficiently covered in the public submission. The first is, it is bad history. I'm reminded of Donald Trump, who there are deals done by very willing parties, but he rewrites the history and then insists that his view is to be imposed on the deal, irrespective, without consulting the party. So it's bad history. Our understanding of Te Tiriti has evolved and is evolving. Any statute such as this bill will fossilise that understanding, restricting its ongoing organic development. So it'd be better if the bill didn't proceed. Bills should not make history. My submission second point is the Court of Appeal stated a set of treaty principles in 1987. Those principles are foundational to social democracy, such as we are. It is critical that any statute of Parliament does not override nor downgrade those principles. And it would be good if Parliament was to separately acknowledge the Court of Appeal's principles. I'm happy to elaborate any aspect of my submission. And in case you've forgotten it, I have the
submission.
Thank you, Brian. We do have copies of the submission.
I know, but I thought you might want to have the principles.
Fair enough. Good one. Okay, thank you. Thank you for your opening submission, and thank you for being with us, given your recovering surgery. I'll hand over to the committee to ask some questions. Does anyone have any questions? We'll start with Todd Stevenson.
Thank you. Thank you for being here. Just looking at your submission, I want to make sure I understand this. So do you think that we should be legislating the Court of Appeals principles?
No, I don't think it would be appropriate for Parliament to legislate the principle. It would be appropriate for Parliament to acknowledge them.
Right.
You've got other instruments. You've got other ways than just legislating.
Okay, and what do you think that would look like?
Well, I'm not an expert on parliamentary procedure, you are. It would be appropriate for members to mention in their speech, be appropriate in the report back to mention it, and it's not impossible that there's a procedure in Parliament which there would be a general acknowledgement of those principles.
Thank you, Todd. Thank you, Brian. I'll go to Steve.
Yeah, thank you for your submission. You speak about the evolution of our understanding of Te Tiriti and the value of that. Do you think there's been some commentary on the fact that part of our democracy is the judicial interpretation of law and judicial assertions made about what various intentions are? And do you agree with the assertion of the likes of lawyer Natalie Coates that that is actually an important part of our democracy, the judicial participation in understanding the meaning of our constitutional foundation, but also interpreting laws?
Yes, I think the rule of law is a fundamental part of democracy. And I think in my main submission, I comment that the courts themselves have evolved their account of what those principles are.
Yeah.
And I'm not uncomfortable with that. And if you don't particularly like a principle of the court, you're entitled to pass the bill. But on the whole, I wouldn't.
My follow-up, I guess, is that it's right for us to have a concern that determinations on the facts of history or the text of an actual document created in 1840, or even something such as rights, should be put to a majority determination, such as through referendum. Surely facts, history itself, and rights cannot be decided by referendum.
To go back to my Donald Trump example, he got a majority of the votes. That doesn't make his facts correct.
Thank you, Steve. And Brian, I just misunderstood what you were tabling. So we've received that copy of your statement that you made today. So we'll table that as a supplementary submission.
I just had a supplementary question in your answer to Mr. Abel. You said that if we didn't agree with the principles of the Court of Appeal, you do think it's within Parliament's prerogative to pass a law then to...
Well, you're doing that that on the foreshore, aren't you?
Right. So I suppose what I'm asking.
I don't rule it out.
Yeah.
And certainly on this particular matter, I would be appalled if you were to change the Court of Appeal rulings on.
Right. But you don't think it's out of the question?
No.
Okay.
And it doesn't.
Thank you.
Thank you, Todd. Any further questions for Brian Tuck?
Kia ora, Brian. Tēnā koe your kōrero. Thank you for your submission. I've got a fairly simple one. You know, given we've got all these pieces in play, we've got the government, the judiciary, there's Te Tiriti o Waitangi, there's the government and Māori, and then the parliament and all of that. But just simply, do you think it is an okay approach or a good approach for Parliament to be creating bills to move through the government system about Te Tiriti o Waitangi without having first spoken to their Tiriti partner, i.e. Te iwi Māori?
Well, it depends on the circumstances, but this particular bill completely reinterprets the treaty. Certainly is not what people on the treaty grounds thought. It's not what generally people have thought over the time. And so that one, no. On the other hand, I don't mind, but it would depend on the circumstances.
Ka pai, kia ora.
Thank you. Thank you, Brian. That appears to be all the questions. So we appreciate your time with us this afternoon and being with us today. Thank you. We will now move to the next submission. This is from F2. And I think we're having a hybrid submission in person and online. So if the team in the room can come to the table, I'll just give Brian a chance. And if there are people online, there's no online, just in the person? Okay. Folks, welcome. Thank you for presenting before us today. We have you for 10 minutes, so I'll hand over to you to start your presentation.
Yeah.
All right.
Kia ora, and thank you for this opportunity. I just thought we'd just start with some introductions first, and I'll hand over to Nia, my colleague, first to make an introduction. Thank you.
Oh, kia ora and warm Pacific greetings, Ngā Rangatira. My name is Nia Bartley. Tangata Tiriti, tangata o le Moana, Wellington, born and raised. I'm the elected Central Regional Representative of the Air2 Union Executive Board. I'm also on the Air2 Women's Committee and an NZCTU Committee Pacifica co-convener. Our members do not support this bill. It is the exact opposite of kotahitanga. This bill has conjured negative, toxic rhetoric, not in the best interests of Aotearoa. This bill majorly undermines and tramples on the mana of tangata whenua. It is an affront to their human rights. Kill the bill. This bill is disrespectful and undermines the tino rangatira status of tangata whenua, distracting division by design. Kill the bill. Toi tū te tiriti. Now I introduce you to our co-president of the Air2 Union, Muriel Tūnoho.
Kia ora, ko tainui tōku waka ko Saki Huku tōku hapu he uri ahau o Raukawa ki Uta, ko Raukawa ki Tai, from Muriel Tūnoho ahau. I'm very proud of my Māori heritage. I'm also a descendant of Hokowhitu McGregor and Lydia Shasha. So I'm also proud of my tupuna and their Scottish and Italian whakapapa too. I'm a mother of 2 sons and a nanny of 6 mokopuna aged from 4 weeks to 18 years old. My husband is a Pākehā, born to an Irish Catholic parents. I personally oppose the bill because of the distrust and disinformation about Te Tiriti o Waitangi being used to create division, remove our Indigenous rights and to diminish the mana of our tupuna and mokopuna. But I am here today as the co-president and life member of Air2 Union to speak to our union's submission to oppose this bill. Just as some background and a reminder that Air2 is the largest private sector union in New Zealand, and we make this submission on behalf of our 48,000 members. 15% of our members are Māori. Our members also work across many diverse industries, including aviation, communications, community support, services, engineering, infrastructure and extraction, manufacturing and food, and public and commercial services. Thank you for the opportunity for us to expand on our submission. One of the big problems we do have with the bill is about the poor and damaging process that has seen this bill ushered into Parliament. As a union, we negotiate hundreds of collective employment agreements with employers every year. These agreements are negotiated in good faith and cannot unilaterally be cancelled or amended by either party just because the party no longer agrees, in hindsight, about the existence or interpretation of clauses they had previously negotiated. Discussion between the parties can take place at any time to reach agreement on any interpretation issues. However, if no agreement is reached, either party has access to the existing judicial processes to seek a legally binding judgment on what the clause means. If an employer deliberately ignores this process and unilaterally changes our members' employment agreement conditions, a revolt would immediately break out, similar to what you've already seen with over 100,000 people taking action across the Motu in the lead up to the arrival of the hikoi that recently descended on this Parliament. We oppose the Treaty of Waitangi Principles Bill, not just because it is a threat to Te Tiriti or Waitangi, but because it threatens to destabilise the unity that is already growing amongst the peoples of Aotearoa, striving for a better and flourishing future for Papatūānuku and all of your children. So our members have asked us why this bill is even being considered, given the pressing problems currently facing Aotearoa. Many of our members are currently struggling to survive on minimum wages, with precarious conditions and constant fear of job losses. There are 70,000 care and support workers still fighting for pay equity. The care and support sector here needs to be transformed to improve inadequate wages and safe staffing. Tens of thousands of cleaners, caretakers, catering staff, school grounds people and security guards in our communities are battling to earn a living wage just to live with dignity. The extravagant amount of cost and time wasted to hear this bill has been prioritised over the bread and butter issues affecting all workers and their whānau. E2 is not afraid or opposed to having national conversations about Te Tiriti or Waitangi and any proposed constitutional solutions, but that kōrero must start between the Crown and iwi hapu Māori as a first priority because they represent the original signatories to Te Tiriti. We acknowledge the important mahi already set out in the Mateke Mai report about some of these issues. In summary, E2 opposes the bill because it overstates the kawanatanga of the Crown and does not allow good faith cooperation between Te Tiriti partners. It deprives Māori of all rights that they enjoyed prior to 1840 unless those rights have been specifically agreed with the Crown in legislation. The New Zealand public was not a party to Te Tiriti or Waitangi, but under this bill, they determine through a referendum the interpretation of an agreement signed by two other parties, iwi hapu and the Crown. It subordinates tino rangatiratanga to kawanatanga. The bill undermines Aotearoa's only expert commission of inquiry on Te Tiriti, the Waitangi Tribunal. The tribunal has issued a scathing report criticising the process and content of this bill. Only one minor party in Parliament supports this bill, while the government's own officials and overwhelming numbers of Te Tiriti experts, academics, the country's most prominent lawyers, and all iwi hapu leaders oppose this bill too. E2 calls on your select committee to reject the bill. The Waitangi Tribunal report stated, quote, that the bill would be the worst and most comprehensive breach of Te Tiriti or Waitangi in modern times. We've also taken this opportunity for the committee to also consider rejecting the proposal for a public referendum. Public referendum is unfair because it will relate to an agreement between the Crown and Māori representatives. The New Zealand public is not a party to Te Tiriti or Waitangi. That's all I
Good.
to
Thank
say.
you.
Thank
Muriel.
you.
Thank you, Muriel and Nia. We've got time for a couple of questions. First from Takata first and then Steve Abel.
Tēnā kōrua. Tēnā koe Marilyn, te whanaunga.
Right.
I te huhua o ngā kōrero. There's probably not been a more comprehensive, quick summary than that. And given that your guys' work spreads across a lot of the working whānaus that are Māori across the country, what do you think the impact of this bill on the mokopuna of those families is or will be?
I think that's what came up in the previous speaker, is that these are important issues to discuss, but you have to go back to the parties that were first at the table and signatories to Te Tiriti or Waitangi. And if we can't get that right, I think we've already seen some of that damage already done across the motu as well. And I think we're really just sort of flagging there is a lot at stake here, and there's a sense of harm. There's also a growing sense of support of more tangata tiriti as well. It's really understanding the situation. So I don't know if does that address your pātai?
I suppose my pātai just goes a little bit further to the intergenerational impact. You know, how are our kids getting impacted by this, and how are our mokos likely to be impacted, which is an intergenerational impact?
It's funny, isn't it? Because we've got a 3-year-old mokopuna who's probably more fluent in te reo than I am, and more confident as well. And I think it's really important for our existing mokopuna and future mokopuna that are unborn, that they still see a place for them in Aotearoa. They still recognise the promises that were promised by their tupuna and you know, and signed with the Crown as well. So, yeah. Kia ora.
Thank you. Again, apologies. We're out of time on this one, but thank you both for presenting today on behalf of you too. We appreciate your time.
Kia ora. Tēnā koutou.
We're going to move to submission now from Ani Mikaere. Is Ani here?
I am.
Online? Oh, kia ora, Ani. Sorry, you're online. Welcome. Thank you for being present at the committee. We've got you down for 10 minutes this afternoon, so I'll hand over to you to give us your presentation.
Tēnā koutou. E kore rawa au e mihi ki tēnei kaupapa whakaheahea. Koe anō me mihi ka tika ki te hunga e whakapau kaha ana mo te tiriti o Waitangi te take. Ka mihi hoki tēnei uri o Ngāti Whare Raukawa ki a koutou e whakarongo mai ana, mō reira tēnā tātou katoa. I am strongly opposed to this bill, and I take heart from the quality of the many excellent submissions that I've heard today opposing it. I take my submission as read, but I would like to add the following comments. For as long as the principles of the Treaty of Waitangi have been enshrined in legislation, the Crown has manipulated the concept to serve its own implacable sense of entitlement. The Crown has always sought to enforce an interpretation of the principles that gives effect to a watered-down version or watered-down interpretation of the English language document, the treaty, and an interpretation that turns the Māori language document, Te Tiriti o Waitangi, on its head. This bill continues that pattern of behaviour. What sets it apart from earlier efforts, perhaps, is that this time the Crown can't even be bothered trying to mask its true intentions by hiding behind protestations of good faith. This time, the Crown is explicitly, indeed proudly, pursuing an interpretation of the principles that flies in the face of advice from anyone with relevant expertise, including its own officials. It's long been my view that an air of confusion has been quite cynically fostered concerning the true meaning of Te Tiriti o Waitangi, when in fact its meaning is very simple. Te Tiriti, written in Te Reo Māori, was signed by over 500 rangatira and by Governor Hobson. It reaffirmed the supreme political authority, te tino rangatiratanga, of the rangatira, but delegated kāwanatanga to the Crown so that it could regulate the conduct of British citizens who were living here in Aotearoa. In effect, the rangatira were stipulating that the Crown take responsibility for its own people as a condition for being allowed to remain here. The English language treaty was signed by just 39 people, I suspect by accident more than by design.
It stated, of course, that the Rangitira ceded sovereignty to the Crown in return for a promise to uphold certain property rights, to accord them certain rights and privileges of British citizenships. Now, there's never been any suggestion that the implications of the term sovereignty were mentioned, let alone explained, to these 39 people. Now, it's plain that the Crown intended to acquire sovereignty in 1840. However, that intention was never communicated to any of the Māori signatories. The Waitangi Tribunal has rightly concluded that the meaning and effect of the 1840 agreement can only be found in what Britain's representatives clearly explained to the Rangatira and the Rangatira then assented to. The agreement's meaning and effect is not to be found in Britain's unexpressed intention to acquire sovereignty. So the truth of the matter is that the English language document, the treaty, is not actually worth the paper it is written on. Now, the Crown has long tried to fudge the fact that it never legitimately acquired sovereignty, utilising whatever tools have come to hand. And over the past 50 years, the principles of the treaty have proven to be as useful a tool as any, as is amply demonstrated by this latest attempt to make Te Treaty mean whatever the Crown says it means. Principle 1, as described in the bill, represents a flagrant breach of Te Treaty. It unilaterally replaces the delegated authority granted to the Crown by Rangatira in 1840 with a self-proclaimed supremacy. The Crown is giving itself a free hand to exercise sovereign authority unfettered by Te Treaty obligations. Principle 2 of the bill strips the heart out of Tino Rangatiratanga. It transforms Tino Rangatiratanga from the supreme political authority that it was and that it still is, to a grudging acceptance of the shamefully paltry entitlements conceded as part of the so-called settlement of historical grievances. Principle 3, with its frankly facile promotion of equality as a concept, merely serves to lock in and accentuate the social, political, and economic disparities brought about by 185 years of the Crown's abuse of kawanatanga. Now, the Crown has acquired the ability to behave with such reckless disregard for truth or decency, not because it's stronger or cleverer, or because it's in any way superior to the rest of us. The Crown occupies its current position of privilege by virtue of the fact that it has lied, cheated, and infected its way to dominance during the decades immediately following Te Treaty o Waitangi. Now, the precise detail of the process by which the Crown acquired dominance may vary from iwi to iwi, from rohe to rohe, but the general pattern remains depressingly constant. Despite the fervour with which the Crown has sought to control the national Te Treaty narrative, the principles of the treaty have played their part in shifting that narrative over the past 50 years. This is due in large part to the intellectual rigour and the courage displayed by members of the Waitangi Tribunal. Its report on this bill is a perfect example of this, and I commend that report to you. The Tribunal has worked hard to educate the nation, reaching beyond the Crown obduracy to influence public opinion. It's done this despite chronic under-resourcing and an endless succession of governments intent on ignoring or minimising its findings and recommendations wherever possible. However, whatever progress has been achieved since 1975 would be erased with the passage of this bill. This bill, to me, epitomises what I regard as lowest common denominator politics. It panders to the basest of colonial instincts. It incentivises those who have benefited from the immoral conduct of their forebears to support an interpretation of Te Treaty that guarantees the preservation of their ill-gotten gains at our expense. The Treaty of Waitangi Principles Bill seeks to cultivate greed, arrogance, ignorance, and insecurity in order to achieve its goals. As I stated in my written submission, no person with a shred of integrity or intellect would wish to have any association with it. So I urge this committee to demonstrate a measure of integrity and intellect by relegating this bill to the dustbin of history where it rightfully belongs. And importantly, as others have said, by reminding the Crown that its energies would be far better spent coming to terms with the urgent need for constitutional transformation, as so ably foreshadowed by Matakē Mai Aotearoa, by the Paparahi o Te Raki Waitangi Tribunal, and by many others. A kanoi tēnā mō tēnei wā tēnā tātou katoa.
Kia ora, Ani. Thank you for your submission. We've got time for a couple of questions. The first from Steve Abel and then Marimino Kapking.
In terms of your reference, your very powerful submission and your candor is greatly appreciated. Is it cynical in your view to use this concept of equality while the underlying motive is to nullify Māori tino rangatiratanga?
Absolutely. I listened with interest to Marilyn Waring's discussion of equality, and I thought she was bang on. Talking about equality when actually substantively what this bill would be doing would be removing any small gains made towards achieving a greater measure of equality for Māori is disingenuous and extremely cynical.
Kia ora.
Thank you, and Marimino.
Thank you. Thank you, Mr. Chair. Tēnā koe ane kānui te mihi kā koe. Te pai hoki o te rongo i wau whakaaro nui me te, well, te katoa o tō kōrero tēnā koe. You made this statement cynically fostered, which of course there was a smile on some of our faces. And then my question therefore is, to what end do you think? Because that's, I mean, it's just so well put, but to what end?
Yes, the so-called confusion surrounding the meaning of te treaty, it's been deliberately fostered because even though the truth of what the treaty means is very simple, it's a very inconvenient truth for any person who is wedded to the colonial obsession with power. It's a very inconvenient truth, and so therefore they have to try and spin this whole kind of myth about it. Oh, it's so hard, and we have to take forever figuring out what it means. We all know what it means. It's clear as.
Good, Ani. Thank you. That's the 10 minutes allocated for your time today. So I just wanted to say on behalf of the committee, thank you for taking the time to be with us this afternoon.
Kia ora.
Folks, we are now going to move to a submission from Tuwharetoa. But I just want to, just a couple of points of admin before we start. We are approaching, I guess, about 8 hours of submissions today, so members might be getting a bit tired, but just remind members, you need to seek leave to take photos. I know we're in public hearing, but just as a matter of courtesy, just please ask for permission to take photos, in particular of submitters who may not have anticipated being photographed. And that's same for the gallery too. Just please no photos or filming in the gallery. It is live streamed, so it is available for people to see. And the only ones that are available to take photos are the media and parties who have sought leave previously. Just the second bit of admin is that earlier on today, we made a clarification about Hobson's pledge not responding by the deadline. I'm advised that the clerk's team did receive an email before the deadline. However, it was after all of the slots had been allocated. So their invitation would have carried over to the next time we had some slots. So just wanted to apologise for Hobson's pledge for the, I guess, misunderstanding of the misunderstanding. But just to acknowledge that we appreciate them providing the submission as well.
Thank you.
Okay, so let's move on now to our submission from Tuwharetoa. And I think we've got Luke at the table. And do we have Louisa online? Thank you both for joining us. We've got 10 minutes for you this afternoon, so I'll hand over to you to start your presentation.
Me pewhia kenga kōrero atu I a whaia ani. Whaia nora, ko nā te wharetoa tēnei whakatūria ki te matāhua tō tātou nei ariki a te iauhau. Nā reira, tēnā koutou e te poari. Tēnā koutou roto I nei o ngā tini kaupapa o te wā nei. Kore no ki rere atu āmihi. Te tiru wairo te wā nei, o te anō. Rātou ki rātou tātou ngā whatūru pā rātou mā. Me te mia no ki toku upoko a Louisa. Kono rā kia watu te rākau ki a Louisa.
Kia ora, Mr. Chair, committee members, tēnā koutou katoa. As chair of the Tuwharetoa Iwi Māori Partnership Board, I join colleague Luke Rowe to express opposition to the principles of the Treaty of Waitangi Bill on behalf of Tuwharetoa IMPB. I too acknowledge Te Ariki Nui Tatumu Te Hiauhiau, Paramount Chief of Ngāti Tuwharetoa, who has appointed us in the exercise of our roles and responsibilities under the Pai Ora Healthy Futures Act 2022. Iwi Māori Partnership Boards are a recognition of Te Tiriti o Waitangi and the partnership between the Crown and Māori. We have been empowered to co-design solutions that reflect the aspirations of iwi and hapu, prioritise tino rangatiratanga, and ensure meaningful Māori leadership. This approach honours Te Tiriti o Waitangi and provides a model for the Crown to follow in other areas of governance. This bill fails to honour the intent of Te Tiriti. It diminishes the mana and tino rangatiratanga of iwi and hapu and undermines the foundational relationship between Māori and the Crown. While it purports to clarify, it results in confusion and risks damaging trust and eroding the constitutional basis of Aotearoa New Zealand. The Cabinet Manual recognises Te Tiriti o Waitangi as a founding document of New Zealand's government, a principle articulated by the Right Honourable Sir Kenneth Keith in 1990 and upheld today. Any legislation undermining Te Tiriti disregards this constitutional commitment. The bill claims legislatively undefined treaty principles create ambiguity, but this ignores decades of careful articulation by the Waitangi Tribunal and the courts. These reports and determinations on the interpretation of the principles of Te Tiriti reflect the status of Te Tiriti as our constitutional foundation. The regulatory impact statement itself identifies the status quo as the preferred approach. It highlights how existing processes have recognised Māori Crown relations, acknowledged tino rangatiratanga, and maintained constitutional balance. The rationale for the bill provides no evidence that legislating treaty principles would enhance these outcomes. Highlighting flaws in the process. Firstly, lack of consultation. The bill was developed without meaningful engagement with Māori as the Te Tiriti partner. This is a fundamental breach of articulated principles of Te Tiriti, particularly principles of partnership and participation. The Waitangi Tribunal has already found the bill discriminatory and inconsistent with Article 2 of Te Tiriti, citing significant prejudice to Māori rights. Secondly, there's a narrow focus on political commitments. The regulatory impact statement was driven by coalition commitments rather than a genuine intent to honour Te Tiriti. This narrow scope has resulted in misguided and limited analysis, insufficient testing of assumptions, and failure to explore broader constitutional impacts. The key risks of this bill. Firstly, undermining Māori Crown relations. By defining treaty principles in a way that ignores the status of Māori as Indigenous First Nations people who entered a treaty that reflected that status to enable the establishment of the governance of Aotearoa is a distortion of the history of Aotearoa New Zealand. It undermines the significance of Te Tiriti o Waitangi and the purported partnership. Secondly, constitutional uncertainty. Rather than enhancing clarity, the bill undermines established jurisprudence and creates confusion. It threatens to destabilise Māori Crown relations by disregarding the interpretations that have evolved over time. And thirdly, ignoring tino rangatiratanga. The bill fails to recognise iwi and hapu as treaty partners and undermines existing mechanisms that provide Māori with a role in decision-making, such as the Pai Ora Act, which establishes iwi Māori partnership boards as Te Tiriti partners. IMPBs play a critical role in this framework, with responsibilities that extend beyond advisory functions to include assessing, monitoring, planning and delivering health services within their rohe. Their contributions are essential to achieving the objectives of the Act and fulfilling their role as Te Tiriti partners. Fundamentally, this bill seeks to rewrite the basis of Te Tiriti o Waitangi, excluding any recognition of Māori and Tino rangatiratanga. In conclusion, this bill in its current form cannot proceed. It fails to uphold Te Tiriti o Waitangi, undermines Māori Crown relations, and risks destabilising our constitutional framework. This bill must be rejected and a commitment made to processes that empower Māori to co-design legislative frameworks, ensuring the mana and tino rangatiratanga of iwi and hapu are upheld. Therefore, I urge the Select Committee to recommend that this bill not proceed, as Standing Order 299 allows the committee to determine whether a bill should advance. Ngā mihi nui kia koutou, and I'm very happy, as is Luke, to answer any questions.
Kia ora, Luke. We've got time for questions. We'll start with Todd Stevenson, then Mari Mino Kapkingi.
Hi, both. Thank you for being here in your submission. I just wanted to go to page 2 of your submission. You talk about investment in iwi and hapu-led initiatives, and you're talking there about health and education, for example. We know that we spend about $6,000 per person in New Zealand on healthcare. And you're saying, there could be some clauses to kind of give this direct allocation and funding to these initiatives. So if we could introduce a way where someone could opt in to a hapu or iwi-led healthcare system using that $6,000, would you be in support of that?
Opt in. Well, from an IMPB perspective, we have responsibilities under the Act, as I've talked about, that will eventually lead to us being strategic commissioners in our own right. Our mandate and our purview is to ensure that our tribal members have access to best practice medical treatment and prevention. So others opting into an iwi-led health service over time, we would welcome anybody to use our health service. And in fact, our ariki has been very clear that we serve all those who live within the jurisdiction of Ngāti Tuwharetoa iwi. So if you simply want to quantify it in monetary terms, what we're looking for is to embed ourselves within the health system to take our rightful place and have a role and responsibility in maintaining the health and well-being, not only of our tribal members, but anybody who calls the Tuwharerohe their home.
Thanks, Todd. Thanks. What's Mari Mino, last question?
It was a tēnā koe kaurua ko Luke, kāne te mihi. Amongst this, the rhetoric running at times, the words such as ancestry mustn't matter in this instance, like it's not a marker, whether it's at a political, constitutional, political context, so it can't matter. In an IMPB reality on the ground, how do you hear that? How do you relate to that kind of thinking?
Well, from a tribal perspective, we don't relate at all because whakapapa is everything. Whakapapa determines your identity through obviously our connection to our maunga, to our awa, to our rohe, and not only to ourselves as human beings, but obviously the health of our whenua. And because we have roles and responsibilities within that context, then anybody who lives within the iwi or tuwharetoa, we have a responsibility to ensure that their health and well-being is upheld. So our fight for our health and well-being as Ngāti Tuwharetoa, in fact, is a fight for the health and well-being of all those who call Ngāti Tuwharetoa home.
Thank you, Louisa. Thanks, folks. Louisa, Luke, thank you both for being here this afternoon. We appreciate your time. I'd like to invite now who's next on the list? Ganesh Nana to the table. Ganesh is with us in person. Thank you, Dr. Nana. Thank you for being with us. We've got you for 10 minutes this afternoon, so I'll hand over to you to start your presentation.
Kia ora. Tēnā koutou katoa. Tēnā koutou te ina nahi, te ina ia nei me te apopo. Ko tēnei taku mihi nā tangata whenua o te rohi nei. i ngā iwi, i ngā mana, i ngā reo, i rau rangatira maha. Ko Ganesh Ahirao tōku ingoa. I'm a first-generation New Zealander born in Aotearoa to parents who immigrated here as young newlyweds from India many decades ago. I am proudly tangata treaty. I thank the committee for the opportunity to be heard, and I think it's appropriate. I congratulate the chair on his recent promotion. I also wish to acknowledge and mihi to the many tens and indeed hundreds of thousands who will not get such an opportunity to be heard here. I feel privileged in this opportunity and feel their weight on my shoulders, but also their wairua in support of and lifting me in this kaupapa. In addition to my written submission, I wish to emphasise that this bill is not and should not be treated by this committee as any ordinary bill. It requires more than standard processing. Your task is so much more than that. This thoroughly repulsive bill is yet another disingenuous act of total disregard and disrespect for the status and mana of Te Tiriti o Waitangi. And this has caused considerable hurt and harm to Māori. It has magnified, emboldened, normalised and legitimised racist thinking, actions, attitudes and understandings that have hurt and harmed all in Aotearoa, tangata treaty and tangata whenua. I acknowledge that several leaders have said this bill will not proceed beyond this committee stage. That may be so, but that is wholly and totally insufficient. The hurt and harm has already occurred and is continuing to occur. That hurt and harm and disregard and disrespect must be acknowledged, recognised and corrected. As listed in my submission, there must be a formal apology from this House that this repulsive bill ever got introduced in the first place. And there must be concerted and genuine efforts to repair the bridge between Māori and the Crown. While there may be leaders in this room who are comfortable with the bill just being voted down, I am waiting for the adults in the room to stand up and take responsibility. Sadly, I find myself asking if there are actually any adults in the room or in the House. I strongly urge this committee to see themselves as and act as the adults in the room. Nō reira, tēnā koutou, tēnā koutou. Kia ora koutou katoa.
Thank you, Dr. Nana. Plenty of time for questions. I'll open that up to members for any questions. We'll start with Tangi Utuhiri.
Thank you, Mr. Chair. Thank you for your submission. I was interested in your contribution there that the committee should adopt an approach that is more than the standard processing of a bill. Given that there is a huge number of submissions and as you yourself pointed out, the inability for the committee to hear from everyone, how do you suggest the committee approaches that? Separate to the apology that you've called for from the House for the introduction of the bill, but in terms of the standard processing, what sort of advice or suggestion would you give for this committee in terms of approaching it in that way?
Well, I think firstly that recognition that this bill, as other submitters have made the point, transgresses a whole lot of constitutional matters and foundational matters for this country that I am not at all expert in, but at the very least recognise that difference between sovereignty and governance. And if we're serious about constitutional matters and constitutional review, recognise that this House is long behind what has already been started within Māori. If we talk about Mātiki Mai and other processes, Māori have been talking about these things for a lot longer than this current parliament or indeed previous parliaments. And let's have that conversation from a genuine perspective of partnership, as was part of the treaty, and let's have that engagement in a genuine manner. And that's part of adults in the room recognising their own weaknesses, recognising their own status and recognising their own positions of power.
Thank you. Maria Mino Kapke.
Thank you. Ganesh, tēnā koe nau mai aere mai ki tēnei tōwhare. You talked about the emboldened, this whole Seymour bill. It's emboldened this the behaviour, the worst things. And I'm interested in your communities. What have you witnessed? What have you seen? What have you heard? What have you felt in that regard?
Well, I don't want to give them the standing that they don't deserve, but you just need to, and I wouldn't because I've deleted most of it, but you just need to see the inbox messages on my emails alongside many others that I communicate with. You see it in social media and indeed in other media where the disinformation and or misinformation about the understandings of Te Tiriti are being put forward as the balanced view. There's one side and there's another side. We have made as a nation significant progress in my lifetime about understanding of Te Tiriti, recognising the background that I put out in my written submission, starting from literally zero when I was at primary school and through high school. That progress is being harmed and set back undoubtedly by the information that's out there that the treaty was in effect a nullity and you don't have to recognise it because Parliament is sovereign and we're allowed to make whatever legal decisions we like and those sorts of things. It's just not an appropriate or conducive manner to have a grown-up conversation about these important matters if we're talking about Aotearoa in the 21st century.
Thank you. We'll go Rima and then Glenn.
Doctor, thank you for highlighting how young I look. So Doctor, so what's your PhD in?
Economics.
Economics, okay. And so while you worked in 2021, we went into one of our worst recessions in history, but thank you for your comments.
Glenn,
am I allowed to?
There's no need to respond, I don't think. Glenn, thank you. And in your opening submission, you talked obviously about your Te Tiriti is the reason your parents were able to come here. And in your written submission, quote, you say, migrants who have come to this country for many decades are the very embodiment of tangata Te Tiriti. Can you just unpack that a little bit more for us, please?
Well, right from the very beginning, we've got to we'll read Te Tiriti and read indeed the preamble to treaty, very much founded on that immigration discussion argument that fundamental were Māori going to allow the colonisers to come in and settle this place. And so from there, that really does enable, that allows, permits my predecessors, my parents and others to come here and settle and indeed enable them to continue to be here. We are here because our tupuna, our leaders, the Crown and Māori signed Te Tiriti. That is what enables this nation to grow and develop as a Pacific nation of many peoples, not just a nation of Māori, not just a nation of English people, a nation of many peoples based in the South Pacific. And it's from there that we need to look forward. How do we build on the strengths of all of our people coming together?
Final question from Timothy.
Hey, kia ora. Just on the suggestion that you made around the formal apology to Māori, which I think is a good suggestion, and it's, I think, the first kind of suggestion like that today. But I mean, this Crown apologises for all sorts of stuff and continues on with the same BS all the time. So, like, what more can we do that would actually show that the Crown was actually committed to being an honourable partner to Te Tiriti rather than trampling on it all the time?
Well, I go to my other points in the recommendations, and yes, I acknowledge Crown have apologised to Māori for lots of things. The key thing is genuine apology, which is backed up by a package of things around, in particular, I point out the initial steps is very much of the House concerns Te Tiriti o Waitangi and He Whakaputanga as founding documents of Aotearoa and acknowledges that Māori never ceded sovereignty. And that has point that has been made and found by many legal scholars, and indeed backed up by Te Tiriti o Waitangi, the Waitangi Tribunal in its finding in whenever it was, and I'm sure you'll be aware of that. Those are two concrete matters that would at least embed this House recognises its position rather than it being all powerful, but its position as a partner to Māori.
Thank you, Dr. Nana. Thank you, folks, for your time this afternoon. We appreciate you being with us for your submission. I'd like to invite to the table Common Grace Aotearoa, who are with us in person and in Zoom. Sorry, folks. But guys, come on. Please don't interrupt from the floor. It's not a time for participation. Meeting is suspended. Please clear the room. Okay, thank you, folks. The meeting's restarted. I'll just explain what the ruling is there. So the committee has allocated time to each submitter to use as they see fit. We are quite strict on time because we've got a number of submissions to get through. And if we have interruptions or disorder from the gallery, that eats into everyone else's submissions time and eventually means we can hear fewer submissions. So the ruling from the chair on behalf of the committee is that submitters have time to use as they see fit. If they would like to have members of the gallery support them during their allocated time, that is absolutely fine. But once the time has expired and we move on to the next submitter, we will be moving on to those submissions. So feel entitled and welcome to have your supporters support you during your time. But if we come to an end of the submission period, we'll have to move on to the next submitter. And members of the gallery or the public, you are observers in the submission process. You aren't participants unless you are invited by the committee or by the submitter to participate in the proceedings. And even then, it is up to the chair and the committee as to whether that happens. So in saying that, we will move now to our submission from Common Grace Aotearoa. We've got Alex joining us online and at the table. I don't have your name, sorry, but if you can introduce yourself when we start, that'd be appreciated. You won't lose any time from this. Everyone will still get the full allocation from here. So thank you. We've got you for 10 minutes this afternoon. I'd invite you to begin your presentation.
Tēnei te mihi kia koutou, e mihi ana ki o koutou mahi hira he take nawa, he take nui rau atu. Ki tautoko tonu tātou I ngā tikanga o te tiriti, ka tau te tika I runga I te rangi Mārie me te kotahitanga. E te mihi, e te mihi, e te mihi. He kororia te atua, e runga rawa, kia mau te rongo, I runga ki te whenua, me te whakaaro pai ki ngā tangata katoa. Āmene. Tēnā koutou e rā rangatira mā, ko I hopana ahau, no Tuwharetoa me Raukawa, me te arawa oku iwi. I'm a Treaty Justice team member with Common Grace Aotearoa. Kia ora.
Tēnā koutou, ko Alex Johnston toki Whenua. I'm one of the co-directors of Common Grace Aotearoa.
And tēnā koutou katoa, ko Kate Day toka ingoa, ko tangata tiriti ahau. On behalf of Common Grace, we are speaking today to oppose the bill. Common Grace Aotearoa is a movement of 3,000 followers of Jesus from all denominations across Aotearoa that speak up together for climate, economic and te tiriti justice. Our vision is to see a flourishing of all people and the earth by transforming unjust structures in society. We are an independent organisation and so we don't speak on behalf of any church denomination. However, with broad connections into multiple church communities, we can give you a sense of the strength of feeling among the church in support of te tiriti and against the Treaty Principles Bill. We are the organisation that coordinated an open letter from church leaders stating they oppose the intent of the bill and appealing to all MPs not to let it get to select committee. At the time, 440 church leaders signed, including the most senior leaders of Catholic, Anglican, Methodist, Salvation Army, and Pentecostal denominations. The number of signatories is now over 600 church leaders, which to our knowledge is the largest collective action or political statement by church leaders in recent history. The letter stated, we affirm that Te Tiriti o Waitangi protects the tino rangatiratanga of hapu and iwi. The proposed bill is inconsistent with Te Tiriti o Waitangi in that it does not recognise the collective rights of iwi Māori or guarantee their relationship with the Crown. It would undermine what Te Tiriti guarantees and what decades of law, jurisprudence and policy have sought to recognise. As Common Grace Aotearoa, last year we also ran an education program for church congregations about Te Tiriti that has been taken up by 280 churches. This momentum and appetite for education are something that we would describe as a movement of God's Spirit.
So to follow on from what Kate said, why is there such a strong feeling from Christians on this issue? Well, Christians are the inheritors of the legacy of the missionaries involved in the drafting, promotion, and signing of Te Tiriti o Waitangi, and so we acknowledge a duty of care for upholding the mana of Te Tiriti o Waitangi. Like many other Christians, we see Te Tiriti o Waitangi as a covenant, a sacred promise of relationship. It is not just a legal document between the Crown and Rangatira, although it certainly has important legal obligations that flow from it. Covenants in the Bible, like those between Noah and God or between Abraham and God, had characteristics of permanence, terms of mutual benefit, mutual responsibilities, and faithfulness to the relationship over the long term. Te Tiriti and the intent of the parties at the time embodied all, if not all of those characteristics. We believe God takes covenants seriously, and therefore as people seeking to follow God, we take seriously our role in honouring Te Tiriti and calling on the Crown to do so. Jesus said, let our yes be yes and your no be no, and so our words and promises need to mean something.
We want the partnership to thrive. The Treaty Principles Bill breaches that partnership. Te Tiriti is an embodiment of the partnership between tangata whenua and tangata tiriti, where those people are committed to ensuring the best for each other in respect, equality, and kotahitanga. This partnership model is the foundation for a flourishing, peaceful life in New Zealand for all. It is a Kiwi constitutional expression of loving your neighbour as Jesus commands. We sense this is why we have seen so much support across the church for Te Tiriti o Waitangi. By contrast, this bill is being driven solely by the Crown, without input, consultation, support, or agreement from Te Iwi Māori. This is prejudicial and an abuse of power. The content of the bill further undermines the partnership between the Crown and tangata whenua and damages the social cohesion, peacefulness, and mutual respect that the existing partnership brings.
Our written submission details further how this bill distorts the text of Te Tiriti, and we affirm the findings of the Waitangi Tribunal in this regard. And we submit that this bill has caused real harm, as many other submitters have noted. Now, shifting to our recommendations, Christian teaching gives us a very clear steer of what to do in circumstances of a severe breach of a promise like this. We repent, we say sorry, and we turn our behaviour around. So we recommend that this committee recommends this bill be dropped in its entirety. We recommend that the Crown apologise to Te Iwi Māori and take active steps to restore the harm that has been done to the treaty relationship. Thank you for your time and attention after this long day of hearing submissions. There is a big task ahead of you, and we pray that the love, the grace, and the peace of our Lord go with you through this process. And we look forward to your questions.
You folks, we do have time for questions. I'll hand over to members to indicate if anyone's got any questions.
Yeah.
Temple.
Kia ora. Thank you for that. Well, first one's a quick one. Alex, I really liked what you were saying before about the Christian values that could be applied to the way that we understand and apply covenants. You said mutual benefit, good faith, permanence. What were the other ones?
Mutual benefit as well as mutual responsibilities, and a commitment to the relationship over the interest of the South. So those are some, I can recommend the research of Hamish McLean in this regards in terms of the similarities between covenants in the Bible and the kāwanata of Te Tiriti o Waitangi.
Yeah, kia ora. Thank you, Alex. And I guess my other question for the whole group would be, aside from the points you've set out in your submission and spoken to today, are there, 600 church leaders, that's pretty massive. And obviously there'd be a diversity of reasons as to why they signed on to the open letter. And I wonder, are there any other things outside of this bill and the submission that you think drew people to supporting the open letter? Like one I'm thinking of is maybe the desire to avoid disharmony, or some other reasons why people might have been drawn to supporting your letter.
Yeah, I mean, I think, like you say, there's a lot of reasons, and but it is actually quite a bold statement for church leaders to make, given that their congregations are diverse, and yet here they are taking a stand, which is rare. So I think our words need to mean something. We have a history that ties us to the the humanitarian movement that called for there to be a treaty, and then the dissemination of it, as well as the translation and, all the good and bad that has come with that. But we have a role to play now, and I guess we feel that. So that's another reason, as well as seeing the harm, and seeing ahead to the harm that could be caused, and disharmony too.
Thank you, Kate. We've got a question from Taika Ferris, possibly the last one.
Kia ora koutou. Thank you for your submission. The churches have played a large role in colonisation, and they're still here, and they provide a lot of good, and all of those types of things. You guys are fairly young people, so I'm interested to hear. You guys, you don't all have to answer, but what's your aspiration for the treaty and the churches is going forward?
Oh, that is such a good question. First off, we do just acknowledge the role of the church in many ways, and partnering sometimes in taking land or in benefiting materially from the harms of colonisation, and that is something that we own as well with our legacy as being part of the church. But that also gives us this responsibility to take opportunities to stand with Māori, as tangata tiriti today, and for the church, to restore the harm that we have been involved in. What's our vision? I guess, the church is representative of the breadth of New Zealand in terms of Māori and tangata whenua and tangata tiriti. I would hope that we would show that partnership within our own institutions, but also that we can play an active role in rectifying the harms of colonisation where they appear structurally, and moving towards far greater recognition of what Te Tiriti promised.
Thank you. Look, thank you, Common Grace, for your submission and for your continued submissions to the Justice Committee. We do appreciate receiving them. Thank you. We're going to move now to submission first from Vincent O'Malley. If Vincent is here, I'll invite Vincent to the table.
Mr. Chair, can I just inform them?
Yes.
Sorry, not really. It was just a previous situation, just to clarify the perception of the gentleman that did kakaranga. He wasn't actually part of this gentleman's presentation. So he was just showing and acknowledging it. It wasn't anything other than that. I just think it.
No, I understand, but members of the gallery cannot interject and they cannot participate in the.
Support your recorded, Mr. Chair. 100%.
We'll go now to submission from Vincent. Thank you for being with us. We've got you for 10 minutes this afternoon, so I'll hand over to you to begin your presentation.
Tēnā koutou katoa. Thank you for the opportunity to speak with you today. I'll keep my opening comments relatively brief, so we've got some time for questions. I've worked as a professional historian researching and writing on the treaty and other aspects of New Zealand history for more than 30 years, and I strongly oppose the Treaty Principles Bill. It's a bill which, while purporting to define the principles of the Treaty of Waitangi, in fact bears almost next to no relationship to that document. The first principle states that the executive government of New Zealand has full power to govern, and Parliament has full power to make laws in the best interests of everyone in accordance with the rule of law and the maintenance of a free and democratic society. In 1840, Great Britain was not a democratic society, and the ruling classes were genuinely appalled at the prospect that it ever might be. The British weren't exporting democracy to New Zealand in 1840 because they didn't have it at home to export anywhere. Now, it's a Te Reo Māori text that is the definitive document under international law, and Article 1 of this doesn't grant the Crown unbridled power to govern all. The kawanatanga it accorded the Crown was instead more limited. As the Waitangi Tribunal concluded in 2014, in February 1840, the rangatira who signed Te Tiriti did not cede their sovereignty, but rather agreed to share power and authority with the governor. The second principle contained in the bill is a willful and egregious attack on Article 2 of Te Tiriti on multiple grounds. It ignores the tino rangatiratanga promised to the chiefs and their people in 1840. One party to a treaty cannot unilaterally alter its terms, nor can Māori rights be confined to those conferred through treaty settlements. The kawanatanga secured by the Crown under Article 1 is constrained by the Article 2 promises to recognise and respect the rangatiratanga of Māori communities. The third principle, emphasising the equality of all before the law, bears no relationship to the actual contents of Article 3 of Te Tiriti, which guaranteed all the rights and privileges of British subjects to rangatira Māori and their people. In 1840, the term New Zealanders referred solely to Māori. The context in which Te Tiritia Waitangi was agreed is also important to remember. In 1840, 80,000 Māori outnumbered and dominated the 2,000 non-Māori resident in these islands, not just demographically, but also militarily, economically and culturally. For a long time, the treaty was viewed by the Crown and non-Māori as at best a historical curiosity rather than a binding and enduring agreement. For the past half century, our country has been immersed in a major process of historical reappraisal. We've had to look at ourselves in the mirror, and what we see reflected back at us has not always been flattering. It's been a difficult, fraught, messy and protracted process, but also an essential one for the future of our country. This bill would put at risk the considerable progress that has been made since the 1970s and needs to be emphatically rejected. Thank you.
Thank you, Vincent. Short and sharp. Very much appreciated. We've got questions from Ginny Anderson and then Tamitha Paul.
Thank you for your submission and also for your wider contribution in terms of this debate over your time as a historian. We've gone through a number of paths today, but I'm interested on your predictions on where this will go. So there's a lot of misinformation about what the courts do versus what Parliament does, what people really think, what equality is. There's been a lot of things bounced around today, but I'd be really interested for you to take the breadth of your background and make a prediction about where this piece in the timeline, whether that really takes us backwards or not.
Kia ora, thank you. Well, I think a big part of why we're where we are today is because generations of New Zealanders didn't learn our history, or if we did, it was a kind of rose-tinted version, greatest race relations in the world and that kind of thing. And what I've always said to groups when I'm invited to speak to them is we need to be upfront and honest about our history, warts and all. And that's the only way we can mature as a society. In order to do that, we need to have people who have that knowledge of our past. And that's why the decision in 2019 to teach New Zealand history in all schools is incredibly important in the longer term. That's a hugely transformative decision. But I think us adults are we need to catch up on that history as well. Otherwise, there's a kind of void, and that allows misinformation to grow. And, you know, I hope that this bill is quickly put an end to, but that misinformation will linger as long as people don't have that ability to see through it, because they don't have that historical awareness and context.
Yeah, thank you.
We're going to go to Tamitha, then Todd.
Kia ora, Dr. O'Malley. Stoked to have you here because there has been some interesting recollections of history that have come to us today. And I wanted to bring up two just to get a response from you. One of them was Māori did not cede sovereignty because there was no sovereignty to cede from them, if you get what they're trying to say there. And then the other one was, actually, maybe let's start with that one and then I'll find the other one. What's your response to that?
Well, in 1835, the United Tribes of New Zealand signed an agreement called He Whakaputanga, the Declaration of Independence of the United Tribes of New Zealand. And in that document, they declared their authority and their sovereignty over the country, which used terms like the kingitanga and the mana i te whenua. And that document was recognised by the British Crown. And that's the reason why in 1839, when the British decided that they needed to intervene further in New Zealand, they said, well, we've already recognised He Whakaputanga as you know, the United Tribes is essentially a sovereign people. So the British acknowledged that at the time. So it's completely wrong today to say that wasn't the case. They did. Otherwise, there would have been no treaty.
And the second one, sorry, real quick, was a KC said to us this morning that Māori were not a sovereign nation because we were warring. What would you say about that?
Has he heard about the 100 Years' War in Europe? Or, you know, Europe in the 19th century was not exactly a peaceful place. Sure, the British Empire was at war most years of the 19th century somewhere around the globe.
Yeah, thank you.
Go to Todd.
Really helpful. Really helpful.
I'm going to go Māori Mino Cup King.
We had another submission this morning actually talking about the ratification of the treaty by the British Crown. You may not have tuned in for that, but this gentleman's contention was basically that the Crown, the Queen at the time, actually only ever ratified the English version, and basically his contention was that at the end of the day, the texts were actually so different that no agreement could actually be reached in practicality. Have you looked at this at all, or got any thoughts on that?
I didn't hear that particular submission, so I probably can't comment on it in too much detail. But I mean, this does go to the essence of the problem in that the British relied on this English so-called translation, which bear no relationship to what Māori had signed up to in 1840. And Māori had entered into a relationship that they assumed was based on reciprocity and partnership and good faith and so on. And the Crown assumed that they had acquired sovereignty over the country. And those two versions of what had been entered into in 1840, it wasn't resolved in 1840. It took decades for the Crown to impose its authority over Māori communities, even into the early 20th century. It's been the raid on Mangapahatu in 1916 has been described as the last shots of the New Zealand Wars. So there's a long history here in terms of the disjunction between, as I say, the so-called English translation and what Māori actually agreed to in 1840.
Thank you.
Thank you. Māori Amino to finish.
Thank you, Mr. Chair. Tēnā koe, Dr. Natalie. You said warts and all, and talking about this whole, the have to have that knowledge, or that there is a knowledge gap. I'm using the word knowledge gap. In your mind, is it, could it be that simple? Is it that simple an issue that could actually be filled if we fill that knowledge gap? Because it seems so profound that it's that we find ourselves here simply because people just don't know. Can it be that simple?
I think that's a huge part of it. I'm not saying the process of learning is going to be easy, because for some it's deeply uncomfortable.
Yes.
You're learning those stories about, you know, what your ancestors may have done in the past. But the thing I always say is the purpose of learning that history is not to make anybody feel guilty or ashamed about the actions of their ancestors. It's to ensure that we can carve out a path ahead for our future. We know where we've come from. We need that. We need that grounding. We need that identity. And that can only come from being honest with ourselves, I think.
Yeah. Thank you, Doctor.
Thank you, Dr. O'Malley. Thank you, folks. That's the time for the submission this afternoon. We appreciate you being with us in person for this. So we now would like to invite New Zealand Nurses Association to the table. And I'm not sure, we don't have the name of the minister, so if you can just introduce yourself.
Gary Nicole. Gary Nicole.
I'll ask you to start soon because I can't hear you.
James, I've got a question.
Thank you. Thank you for being with us. We've got you for 10 minutes this afternoon, so I'll hand over to you to start your presentation. Sorry, I couldn't hear your name from down here.
Kia ora koutou katoa, ko Waihua tuakine, ko Manga Haruru, ko Taki Timu Te Waka, ko Ngāti Kahanunu Te Iwi, ko Ngāti Tū Te Hapu, ko Keri Nuku tōku ingoa, he kai whakahaere tōputanga tāpohi kai te aki o Aotearoa. And I'm joined today with our Chief Executive, Paul Golter, for the New Zealand Nurses Organisation. I'd like to start that NZNO requested to be heard in person on the Treaty Principles Bill because we have grave concerns this proposed legislation will worsen Māori health outcomes. This legislation plays with Māori lives. It says it's okay not to give attention to the need to fix the health system that is killing our people. Tangata whenua are not the enemy. They are not a threat to this country. Here are some facts. They die faster and in bigger numbers than non-Māori. Māori don't live as long as non-Māori. Māori don't earn as much money as non-Māori. Māori are less likely to own their own homes. As Aotearoa's largest professional union in health, we represent more than 60,000 nurses, midwives, students and healthcare assistants, including more than 4,000 kaimahi Māori. As you would have read from our submission, Māori nurses are on the front line of the inequities in the health sector, where Māori are more likely to suffer from preventable illnesses, comorbidities, and shorter lifespans. Te Treaty provides a foundation to fix the serious and dire health problems faced by Māori, something I'll expand on further. We acknowledge the pre-existing rights of Māori as tangata whenua and Te Treaty o Waitangi as the founding document in Aotearoa, New Zealand. The legal precedents. The Crown has never met its obligations under Te Treaty within the health system in its failure to work in a meaningful partnership with and deliver equitable health outcomes for Māori. Despite health strategies that have been equity-based aspirations, system, design, funding models and service delivery are not equity in their results. This bill legitimises those breaches rather than readdressing their injustices and ensuring Te Treaty is honoured in the design, delivery and monitoring of the health services. It arrests and reverses all progress made to improve Māori access to culturally safe care and improve major and persistent inequitable health outcomes with other New Zealanders. This bill's reference to everyone being entitled without discrimination to the equal enjoyment of the same fundamental rights fails to account for the systemic racial discrimination against Māori within the health system and the existing role of Te Treaty of Waitangi in achieving equitable health outcomes for Māori. This is also in contradiction with the intent of Te Treaty, which recognises the collective and holistic rights of iwi and hapu and the Crown's obligation to actively protect them. The bill is contrary to the Paeorder Act. The bill represents the government breaching its own policy and objectives of the health sector. The bill proposes uninvestigated sweeping changes that impact all legislation that makes existing reference to the treaty principles, the principles of Te Treaty of Waitangi. The Paeorder Act sets a legal imperative for the Crown to actively protect and improve Māori health and well-being and address the disparities. This bill is inconsistent with the obligations on the Minister of Health to fulfil Section 6 of the Act, and the impacts of these contradictions have not been investigated. The culturally safe care and unique position of Māori nurses to achieve health inequities. Cultural safety is critical to ensure engagement and empowerment of Māori users of the health system. If our health system is not safe for Māori, we will see further obstructions to access and widening health disparities between Māori and non-Māori. Māori nurses hold a unique and essential position within the healthcare, blending their professional nursing expertise with local knowledge and relationships with community and kaupapa Māori models of care. To reiterate, NZNO appears here to reflect the collective and individual role of nurses to be an advocate for the community, for patient, for Māori. It is our moral and ethical responsibility to call out a system that is chronically and systemically racist and advocate against discriminatory practices. The health system must recognise and allow for tino rangatiratanga and mana motohake of hauora Māori, and this bill is not only distinguishes these rights and aspirations, it will directly worsen Māori health outcomes. Kia ora.
Kerry, Paul, thank you both. Members' questions. Start with, I think we've got one from Ginny straight away, and then Marty Minnie.
Thank you.
Kia ora, thank you very much for your submission. We've heard a lot about what is equality today and how we examine that through a treaty lens. I'm really interested to understand the impact on Māori service delivery, the potential impact for this bill and some of the ideology that underpins it. In particular, what are the risks with not being able to provide Māori with culturally appropriate nursing services?
We're already seeing some of that risk now. We have got an underrepresentation of a Māori health workforce. After years of campaigning and activating for a workforce, a Māori workforce that matches the population, we're historically under target And if you look at the current policies that are put in place, the workforce strategy, there is no intention of the current government to invest in increasing Māori workforce, which is well needed because what we know works is for Māori services. We're also seeing huge discrepancy in terms of funding allocation to any Māori health service. And if we look at the historical issue once again, that Māori get paid disproportionate. Those that work within Māori and iwi providers get paid disproportionately lower than those that work within the hospital systems. Equal work of equal value should be the principle that we uphold here, but clearly we are allowing this gap to continue.
We'll go to Māori Mino Cup.
Thank you, Mr. Tēnā koutua, Niki tēnā reo. You opened up by referring to tangata whenua, not the enemy. So how do you hear words such as, and you might have just touched on it, serializing that answer, that we get preferential treatment, might get preferential. The minute people hear generally, the supporters of the bill anyway, talk about Māori for Māori, it's an instant reaction, an allergic reaction nearly to that means that it's preferential. We get additional rights or resource or whatever it is. Can you just talk to that? How does that you feel, think?
I've been a nurse and a midwife and worked in the health sector for over 30 years. And certainly those comments of preferential treatment are not part of what I see every day. The struggle for those that use the health system, and in actual fact, the reverse. Māori are not privileged within the health system. The Y2575 recommendations and our nurses that gave evidence clearly demonstrated Māori are not given preference within a health system. If anything, Māori are struck off. Māori are turned away from ED departments. Māori are not having the same access. Māori can't afford to access and go to doctors or go to clinics. So the worsening conditions is perpetuated. There is no privilege within the health system.
So it's time for one last one if anyone has any further questions.
Thank you, Mr. Chair. So an extension to that thinking then, Nick, is that, well, if that's true, then if those conditions that you've just referred to, that is simply because we're lazy, we don't do enough, we're too fat, blah, blah, blah. That thinking heads down that pathway of thinking, and therefore it is simply our fault. The state of it is our fault. We get here because we don't do enough, and all of those horrible but silly things, but they get said, and then they get believed, and then they get embedded in the stuff that we're having to deal with like today.
And what a lot of Māori nurses that work within departments will tell you is that prejudgment often is deeply entrenched in the behaviour within the practice, within the system, within the attitudes and professional people as well. So our people will not go to services because they know that that's what they're going to get coined with, that it's your own responsibility, that you should be able to afford and the treatment that's necessary. That is far from the truth.
Thank you. Thank you, Kerry. Thank you, Paul, both for joining us this afternoon. We appreciate both your patience and folks, we are now going to move to our last submission of the day. I'd like to invite Gerrard Eckhoff up to the table. Jerry, if you want to come up and join us.
Yes, questions.
Save us some time, and they really do. Smart.
Jerry, thank you for joining us. I invite you to take a seat if you'd like.
Sorry, Chairman, I with noise, my cochlear picks up everything.
Oh, okay.
It's much easier when it's quiet.
Yeah, so what I'll do is I'll just ask for some quiet in the room and then I'll invite Jerry to take a seat.
Thank you. If I may, I'd like to stand for a moment. Committee, I just wish to acknowledge with some real regret the passing of Dame Taranaki. I can't recall ever speaking with Dame Taranaki when I was in Parliament all those years ago, 20 odd years ago. Not one conversation. But I think we took turns at smiling at each other as we passed down the corridors. And from what I understand, that was very much the way Tariana was, or Dame Tariana, excuse me if I'm not addressing her correctly. I admired her a lot, and she's one of my very special politicians of this last couple of decades, I guess. Yeah, perhaps I should. I'm unsure, and I think this is it's important to me anyway. I'm unsure if it is remembered that Dame Tariana once gave her parliamentary questions to ministers to the ACT Party. I was there at the time. Caused a little bit of a furore, I must say, but she did. And she was obviously unable to attend on that particular occasion. So she gave her question to ACT, which was asked and answered. I've always taken that decision of Dame Tariana as a real mark of respect. Maybe trust somewhere, but I thought that was pretty special of Dame Tariana, and I thank her, if I possibly could, to this day. There's another issue I'd like to go back 32 years, and I know it's pretty unusual, but I went to a very large meeting in Dunedin. It was to do with the Greenstone Valley, and it was to do with Ngāi Tahu and settlements. Doug Graham was the minister. I don't, to this day, know why I went. It was 2.5 hours travel there and then back again, of course, 5 hours. I spoke at the very end of the meeting, after everybody else had said, under no circumstances do you give that land to Ngāi Tahu. It's a fishing river, it's this, that, and the next thing, and it's important for recreationists. Something possessed me to get up and make a wee speech. And as I recall correctly, I was the only one that got a round of applause all night. I asked the minister to give that land to Ngāi Tahu, 56,000 hectares, I think, it's big patch. And I'm pleased to say he did. So sadly, it was the most effective speech I've ever given in my life, I think. But to the matter in hand, and I realise I'm probably wasting some time here, but my first question is, where does it end? This question about the treaty and the principles and stuff. My understanding was there are 3 principles to the treaty, and now I hear people like Winston Peters say, well, they're not treaties. So are they treaty? Are they principles? Are they clauses? Are they articles? Or is it some kind of covenant? And I think it's not unreasonable for the party or anybody to ask, what is the truth of the matter? What does it actually mean? Because I don't really know the difference between a covenant and an article, or an article of association. Is that what it is? I don't know. But we need to determine these things, but how do we do that if we don't debate these issues fairly and openly and properly, and without the acrimony that is so characterised this debate so far? I think clarity is good. I've read Sir Aparima Nata. If he is wrong about the treaty, what was it that he said is wrong? I've never heard anybody tell me what it was that is wrong. So again, we need to have discussion about these things so we can get to some sensible conclusion. But I would say that this matter is rightly for the legislature, you people, to the Parliament to manage. It is not for the judiciary. Just recently, 40-odd King's Councils issued a preemptive strike, as I would call it, against the bill by describing it as evil. And that we, the public, and I took this personally, as having my ignorance exploited by the bill. This was for 40 King's Councils. So what faith am I now, as an ordinary citizen, of course, meant to have in the judiciary that has actually happened? So I was absolutely delighted to read that 500 Maori leaders, I think that is the right expression, contacted the monarch. And in doing so, they immediately invoked the Privy Council. The monarch cannot get involved in any of these things without being advised by the Privy Council. That is essential. To me, the Privy Council is the finest of the finest, the best of the best. And for some extraordinary reason, we got rid of them years ago. We need them back. And if this suggestion, and I'm sure others must have made this, I think the role that they played, because they will have articles, documents, all the information that has occurred from, well, since the time the Crown was involved, I guess from the 1820s or right through to the signing of the treaty. They will be privy to all this massive amount of information. But most importantly, they're independent. They are totally independent of this country and can make decisions or give advice, I should say, not make decisions, but give advice to our country. And I think that is something that we desperately need, given the division that we are seeing. I'm wondering whether I'm seeing a division here in this select committee.
No.
There shouldn't be. But I'm seeing the opposition on one side and perhaps the government on the other. Chairman, I'm not an authority in any way, shape or form about these things, but that should not be. It should not be. Because we, the people, actually look to this select committee for unanimity to work together to find solutions. This is not about the LAC party. It's not about National, New Zealand First, Greens or Labour. Not about them. This select committee is not about them. It is about you folk working together, because you are people of repute. You are people of character. And if you have to say to your various parties, look, we've got to find solutions to this, I would expect you to do so. I deeply lament, as I said earlier, these preemptive strikes. And I'm even sorry, very sorry, that the Prime Minister seems to be commenting on these matters for whatever reason. I keep thinking this thing, conflict of interest. Where is all this sitting? Where does that sit? Because I'm told on the regional councils, you can't have a conflict of interest if you sit in judgment. Where is the conflict of interest here? I think it could be massive. And that's why I think the Privy Council could help us out enormously. Finally, well, it's not finally, I've got a lot here. Look, we can work together. River authorities, we're doing that now. I think they're brilliant. And I spoke to the late John Luxton some time ago, and I believe it or not, I couldn't get a word in. He was so enthusiastic. We can do that. And that is involving Maori at every twist and turn of a river. We've got the mighty Clutha. We've got the Pomahaka. We've got, well, the Waikato and all these, forget about the power generation on them, but we've got these great rivers that mean so much to everybody. And I understand the significance to Maori. So I would really encourage the Select Committee to think long and hard about starting down that track of evolving together, sitting around tables and working. And it's not about the colour of your skin or your ethnicity or anything of that. That is about what you can contribute to our society to make it a bit better. I don't want to ever, and I don't want, well, I was hoping maybe my grandchildren might have been able to come today, but I don't want to have them looking back in anger at what is happening. And I think so many people, I'm from way out in the south and perhaps bits different down there, but I don't want to have my grandchildren looking back over their shoulders all the time at what is going on in this country, and the expectation that I have is that the bill was here, put in place to start the discussions, have a standing committee or something. I'm many years ago since I've been here, and I'm not even beginning to try and suggest things, but other than the Privy Council, I think would be of enormous value if it's possible, and if it's not possible, make it possible. You can do anything you like.
Thank you.
Thank you.
Probably a very fitting way to end up. We are over time now. It's okay because you're only eating into our time and no other submitters, so it's actually fine. But I will wrap it up there and just thank you for coming along. It is a very nice way to end the day. I think you make a good point about the seating arrangements, perhaps alphabetical.
I was starting to think it wasn't worth it sitting here all day.
But thank you, Jerry. Thank
you.
I
appreciate
It was nice,
the offer to speak.
News all day.
But members, that concludes the oral hearings for the day. We've done 8 hours and 44 minutes with a 15-minute break. So I just want to acknowledge